Hey guys, I hope everybody is doing well. This is an unplanned live stream, but if you spill in, happy to have you guys here. It's going to be good to have a live chat going. And shout out to Replay Crew. We are doing this stream because, we've been waiting. Someone needs to sue that jail. Well, we now have a class action complaint filed. This is a federal complaint. It's filed with the United States District Court here in the Northern District of Georgia. And two of the named plaintiffs, we have Nkenegen Hambrick and we have Shannon Jackson. That is Shannon Stillwell Jackson. So familiar name here. And again, this is class action. So there are going to be a group of unnamed plaintiffs. If the judge accepts this class, it says that this class is acceptable. They will notify other potential plaintiffs to see if they want to have the opportunity to opt out. If you guys may have gotten like a class action notice in the mail before, it's something that I think probably everybody in the United States that's purchased basic things before or put their information online, you may have gotten some notice where you can opt out of a class action lawsuit if you choose to. If you don't opt out, you can get a part of the settlement if there is one, or a judgment if there is one at the end of the day. If you do opt out, you'll retain your right to bring your own individual suit on your own. So we're going to go through this. This is 62 pages. So it's going to be a long one. When we have something longer like this, I do like to start with kind of a summary, right? In case you just want the top level, get in and out, you'll at least know what's going on. So we do have an article here that we'll take a look at. And let me make my screen bigger. We also have a video. We'll get to see the face of one of the attorneys working this class action suit. And then we can read the full thing. Let's make this a little bigger. And there's a ton of ads here. Holy moly. But the class action lawsuit has been filed against Fulton County Sheriff Pat Labat and members of his staff. The lawsuit, and again, this is going to be, and we'll see it specified in the lawsuit, but it's not like a personal lawsuit against Sheriff Pat Labat. It's in his official capacity in his role as sheriff, and members of his staff. Also directly named, and surprising that the article doesn't say this, is Fulton County Chief Jailer John Jackson, and again in his official capacity. The notorious facility has faced intense scrutiny over inmate safety, crumbling conditions within the facility, and overcrowding. Last month, the United States Department of Justice, that DOJ report, you guys, said conditions at the jail violate the 8th and 14th Amendments of the U.S. Constitution, the Americans with Disabilities Act, and the Individuals with Disabilities Education Act. So, major no-nos here. We cannot turn a blind eye to the inhumane, violent, and hazardous conditions that people are subjected to inside the Fulton County Jail, U.S. Assistant District Attorney General for Civil Rights Kristen Clark said. The DOJ report stemmed from an investigation of the jail, which is funded and operated by Fulton County and the Fulton County Sheriff's Office. The investigation included the main jail in Atlanta, the infamous Rice Street, as well as the annexes. So you've got the Marietta Annex in Atlanta, the North Annex in Alpharetta, and the South Annex in Union City. We find that the Fulton County Jail does not adequately protect incarcerated people from violence such as stabbing, sexual abuse, or even murder, Clark said. The 8th Amendment to the U.S. Constitution protects citizens from excessive bail, fines, and cruel and unusual punishments, while the 14th Amendment prohibits states from denying equal protection of the law. Housing units are flooded from broken toilets, roaches, rodents, and pests abound. And guess what, guys? If you remember, if you went through this DOJ report, there's some money. They had some money that could have been used to do things for the inmates, but they spent that money on certain things. Christmas time is the holiday season. Let me know in the chat if you remember some of those things that they spent that money on were. We'll pull it up on the screen. But they've got standing water, exposed wiring, right? What a combo. You've got standing water and exposed wiring. And vermin make living areas unsafe. The jail does not provide enough food, leaving people severely malnourished, Clark said. The report found that conditions violate the 8th and 14th Amendments. In a joint statement at the time of the report's release, Sheriff Pat Labat and County Commission Chairman Rob Pitts said the county was still reviewing the DOJ report and that the jail and county worked closely with the Department of Justice throughout the investigation. The jail currently houses around 2,000 people, and in recent years has surpassed 3,000. So, oh boy, you guys got it. Look at all the honey baked hams. Yep, they were spending that money on honey baked ham gift cards. We also had a bounce house for an event. They spent it on a bounce house rental for a staff event. I don't really think that they let the individuals that are stuck inside Rice Street or any of these annexes come out and have a jolly good time with these bounce houses or take a trip to Honey Baked Ham to redeem a gift card. The one thing that they did specify that the money that's supposed to be used on the inmates was used for was more tasers. And very good to see you, Chloe Albert's Revenge. Hope you're doing well. But yeah, whole chat is talking about honey baked hams. Like, just ridiculous. Just ridiculous. Yeah, where's the bounce house? Where's the bounce house? Sorry, we can't set it up in here because everything, there's so many jagged edges, it's bound to pop. So sorry, guys. Like, just a whole mess. That report, if you want to check that out, that is linked in the description, as well as the document, this class action complaint that we're going to read. There's also and it like starts right in the middle, you guys, which kind of sucks. But this is one of the attorneys. This is Attorney Harper, representing the plaintiffs in this class action case. So we get to hear a little bit more here from him. Let's, it's 15 minutes long, and I think it's all speaking, so.
Convicted, most of them have not been convicted of a crime. They're waiting for their day in trial. And to come out of that jail with horrific scars on your body, and some of them get killed before they get their day in trial. Back to Mr. Jackson, Stillwell Jackson. Imagine had he got murdered. Imagine if he was murdered in that trial, in that jail, before his trial ended, right?
And he was stabbed several times.
Unconstitutional conditions of non-working locks and these shanks and knives being made by inmates. He could have been murdered. We would have never known he would have got acquitted, you know, from the jury. So it's very important for the citizens of Fulton County to understand that these are innocent until proven guilty pretrial detainees who are coming out of that jail with horrible scars, horrible medical conditions, and some don't make it out at all.
Have you talked to Mr. Stillwell, given his YSL verdict will be released at some point here?
I met with him last week.
I don't know if anxious is the right word, but given the conditions you're describing in the jail, what is his thought on eventually getting out of the jail soon?
I mean, clearly, like anyone else, he can't wait to be released from jail. But right now, he's very relieved that the jury acquitted him of all charges after being in this jail for 3 years and almost losing his life twice. We believe he will be out soon. But we're just thankful that he was able to be alive to see his non-guilty verdict.
And with this injunction of relief, do you take a position on, you've seen the back and forth between the county and sheriff, new jail, rehab this jail. What do you see on behalf of your plaintiffs as the ultimate answer?
This case has been filed, as you can see, against the Fulton County Jail, against Sheriff Labat and the chief jailer. For the reason that were mentioned, it's difficult to hold the Fulton County commissioners liable for what happens at the jail, even though they fund the jail. Sheriff Labat ultimately has responsibility over the jail, so we believe that the proper place for blame here is at the sheriff's office, sheriff's department.
You also named a few corrections officers in the lawsuit as well. How grassroots did you see this problem as, and was that kind of part of the reason why you decided to include employees corrections officers?
Well, let me be clear. The employees were in the Davion Blake case, not in the class action. All right, the class action is just against Sheriff Labat and the chief jailer.
Now the other, and I don't know how much is going to be mentioned in this suit, but I did see it talked about. The other case he mentioned is actually someone that died in the jail. So it's a lawsuit that the estate is bringing forth against the jail in a different capacity than this class action suit.
For every case where you have detention officers who ignore conditions in the jail and they know that their inmates or detainees are put in a dangerous condition and they don't do anything about it, it's called deliberate indifference. And in Davion Blake's case, those officers were aware that he was in a dangerous place. He had been stabbed several times before he was killed, and they did nothing to protect him. And that's unconstitutional. So that's why we were able to list them separately in the Davion Blake case.
So I just want to, if you don't mind, just to clarify. So there's a class action lawsuit that's for injunctive relief. That's against Fulton County Jail.
And the chief jailer.
And
chief jailer.
The chief jailer and against Sheriff Patrick.
Okay.
Right.
And then there's a separate lawsuit for Davion Blake.
Right.
Right. And then you said the lead plaintiff is Shannon Jackson. And
not for that one. The Shannon Jackson and Nkenegen Hambrick are the lead class action plaintiffs.
Okay.
Davion Blake is that's a separate case just for his estate.
Okay.
Yeah.
Just need to get that.
Sure.
Have you been able to talk to Sheriff Labat before you filed this class action, or are you just going to let the courts handle it and go through the legal process?
We believe that enough talking has happened, frankly. I mean, I have been suing the Fulton County Jail for many, many years, as you guys have followed, you know, my career and all these cases that we've been following for many years. The time for talking is over. And the time for just settling cases is also over. It's important to note that, I mean, these families should be paid for their loved ones being maimed and killed, no doubt about it. But the class action lawsuit, we need change in Fulton County. We need the jail to change.
And this is why he's talking about like the broader implications beyond just, I have a grievance and I want some relief for myself, or, you know, as the estate on behalf of my loved one that died in this jail because of the conditions and the lack of care. But they also are seeking injunctive relief with this class action suit, which means all these things that are not good, these things that are not supposed to be happening, or things that should be happening but aren't, we're going to ask that the court demand change. So Sheriff Labat and the jailer, and I gotta remember his name, Jailer John Jackson. Okay, that's alliterative. That's a lot of J's. Jailer John Jackson. We need them to change this stuff, make it stop happening. So we're going to look for that kind of relief, which is very good to hear. Change the screen. I'm sorry, you guys. Hold on, let's go back. Let me go back.
The tangible part is
I just rewound it.
make all the necessary changes, such as staffing, such as the facility so that inmates are not making shanks and knives from jail materials, sanitation procedures to make sure that these kind of horrible injuries don't occur, and then to make sure that the judge has oversight of the jail to report back to the court. So the court is satisfied that these changes have been made. And then the court can issue a ruling that is satisfied that the changes have been made. They have someone to answer to other than the Fulton County Commission, who does nothing. That's the point.
Devil's advocate on that point, because you and Sheriff Labat agree on quite a bit of this, actually. And so, you know, he's been crying to the clouds for a while about staffing, about not having the funding to do some of the things that he needs to fix up the jail. Could it come to a point where, you know, the Fulton County Commission may need to be involved? And I know we run into that question with Soccer Union.
Right, right. And that's a thorny legal issue for us as lawyers. If we sue the Fulton County Commissioners, we get thrown out of court. Right? They're not the sheriff. You can't blame them for the death of Davion Blake. What did they do to kill Davion Blake, right? So we have a hard time suing the commission, to your point. So we have to sue the sheriff because he does have responsibility and his officers do. But the court, to your point, can order the commissioners to make sure that the sheriff has what he needs to make the problems go away and to fix the problem. So we have a case against the sheriff, but I agree with you that the sheriff agrees with us about these problems. He needs the funding. But for legal reasons, we hope that the federal judge understands the legal issues that you brought up and that he's able to order the commissioners to do what they have to do to make sure that the sheriff has what he needs to fix the jail.
So what have you heard from the families?
I'm sorry?
What have you heard from the families?
What have I heard? I mean, the families continue to be outraged. I mean, we get calls almost every day from someone in the Fulton County Jail who's outraged at what has happened. And they continue to just feel hopeless. I mean, even when you see these settlements that have happened, like the Sean Thompson settlement, you hear about other settlements, but the problems continue, right? It is time for the Fulton County to stop paying people off and to fix the jail. I mean, we have to, at some point in time, someone has to make sure, for all of our sake, this is all of our jail. All of us who live in and travel through Fulton County can end up in that jail for any possible reason. And what a horrible situation it would be if you can't make it out, if you come out, you know, maimed or diseased somehow due to conditions.
I don't know if it's me that's tripping or what is this. I mean, maybe it's their feed because it hasn't cleaned up, even though I paused it. Yeah, maybe it's just the way it was coming through. And again, Atlanta News First or whoever's doing this, they like started this statement in the middle, and it's the only feed I could find.
So everyone is exasperated with the issues in the jail because nothing happens. You come case after case, death after death. We're back here again, and nothing's changed. We're hoping that this class action lawsuit, finally a judge will have oversight and force these changes at the jail.
So once the judge establishes the class, who can join that class? Does it have to be people that have been put in jail and have come out alive? Can it be people that have unfortunately died?
You want to speak to that?
It's
Yeah.
people who have suffered what we call an acute injury, an injury that happened at the jail, not something that was existing before, a provable injury that happened as they were detained in Fulton County Jail.
So they have to be alive.
I mean, their families, if they died in the jail and their families can prove that, as he's saying, that it was because of the jail conditions, they will be able to join the class action lawsuit.
And of course, you guys just filed it this week. What's
Tuesday.
What's
Yeah.
next in the timeline?
Yeah.
Next, we're going to file a motion to certify class, where there'll be two judges that get to decide whether the class is adequately defined as to its scope and the people that can join. And then after that happens, we'll be handling damages issues and the real significant liability issues separately.
You don't
For
know
each-
how-
for
you
each
don't- you don't know how long that might take.
That might take a long time.
Yeah, it could take some time, but we would imagine only a few months for the judge to make a decision to certify the class or not, and then we'll put a notice out to the public that the class has been certified, and if you have actionable damages, you are able to join this class action
This is
lawsuit.
Northern District of Georgia.
Atlanta, Northern District of Georgia. But spell your name for them in case they want to.
It's Patrick, Patrick, last name Lead, Leed.
Can you spell the name of Hambrick for me, first and last, please?
Nkengen,
N-K-E.
Kengen, Nkenegen, and Hambrick like it sounds, Hambrick. It's also on the lawsuit, which we'll email to you, but it's Nkenegen Hambrick. Of course, Shannon Jackson, also known as Shannon Stillwell, you know his name.
Is it Jackson Stillwell?
It's Jackson. He's been referred to in the YSL trial as Stillwell, but his legal name is Shannon Jackson,
Okay.
according to him. When I met with him,
Okay.
so I think he
Okay.
would know.
Okay.
I said, man, what is your name?
Right. Let's start with that.
I've heard it so many ways, but he told me Shannon
Oh,
Jackson.
boy.
And he signed my document, Shannon Jackson, so I'm going to take his word for it. That
And
that's
he is the lead plaintiff in the class action lawsuit.
he
That's
and,
the-
well, there are two. He and Nkenegen Hambrick.
Are the lead plaintiffs in the class action lawsuit.
Correct.
But the separate one is Davion Blake.
The estate of
For
Davion
damages.
Blake. For the life of Davion Blake. He was killed, so yeah. His family's bringing that one.
Gotcha.
Yeah.
One last question. What's your hope for clients like Mr. Jackson that's still in custody, or every day new detainees are coming in? It seems like the county sheriff obviously had stalemate here, but
They
the
are.
process you're describing is months until it's classified as a class action
Right.
lawsuit. Then we go through the whole legal process of just
Right.
that suit. You could be talking about years here.
Absolutely.
What is your hope that the county and sheriff can do during that year-long process before you can get that relief?
Well, I mean, look, we all know the issues. I mean, we've talked about them for years. I mean, we hope that just by filing this lawsuit, that the Fulton County Commissioners will do more to help repair the jail before the judge has to order them to do so. We hope they just take it upon themselves to, in the pending time that you're talking about. It could take years. So I hope that the Fulton County Commissioners will make changes before the judge orders them to do so. Yeah, but also, the families must be compensated, obviously, for those who have been injured. But I just want to stress enough that, it's not just about compensation, because it's not fixing the problem. We'll be here 10 years from now talking about another 100 deaths in the jail. But we really, really want systemic change. We want the judge, again, to order and oversee the changes at the jail to make sure that they happen.
What's adequate for any new detainees coming in?
Absolutely, yeah. Yeah, and not to mention that, this is for people who are there now, but, I mean, it has to be fixed for the future. I mean, we have to fix this jail at some point in time. We can't just go on as business as usual with everyone, federal, state, local. We all know the problem, but no one's doing anything about it. Hopefully the judge will.
It's more just a random question, but if the judge does
All right, taking you out to that press conference.
Alrighty. So there we go. There is the press conference from the attorneys representing the plaintiffs in this class action suit. One more short news article. What do you guys think about the timing of this? So this was published today at noon Eastern, so just shy of 6 hours ago. And Fulton County Sheriff's Office says they'll pay $1 million debt to the jail security contractors. That was a whole issue like 2 months ago. The Fulton County Sheriff's Office announced Wednesday, or I guess that was yesterday. All right, I'm late. But this article's from today, that the outstanding balance owed to Strategic Security Company, that's the contractor, who provides guards at the Fulton County Jail, will be paid on Friday. So, what do you think of the timing of this? Channel 2 Action News previously reported that the office owed the company more than $1 million, and guards had been told to walk out after a lack of payment to their company in August. At several points in the intervening months, Fulton County Sheriff Pat Labat had appealed to the Fulton County Board of Commissioners to have funds set aside for payment released to cover the balance and other needs, but those efforts were not successful. So here we are, finally getting some motion even though no luck previously. Instead, while the contract with SSC was needed in August, the Sheriff's Office said that they had found funding to satisfy their obligations as part of their end-of-year closeout process. Still, the Sheriff's Office said, "We are still not adequately funded for an agency of this size with the mandates required. This is an issue that our team has been actively addressing with Fulton County government officials since 2021. Over a 4-year period, Fulton County Sheriff's Office has successfully managed to operate effectively despite..." What? Let's read this again. Over a 4-year period, Fulton County Sheriff's Office has successfully managed to operate effectively. What? Define effectively. Despite only a 15% increase in resources, even in the face of inflationary pressures. The Sheriff's Office went further, saying that while the issue with SSC was being resolved, systemic funding inadequacies remain a critical concern for the agency, and the shortfall in their budget has impacted both contractual obligations and critical operation capacity, which directly affect public safety and community trust. The Sheriff's Office said that the full $1,404,000 owed to SCC would be electronically delivered on Friday. So they're cleaning that up. They're getting it done. What timing? Yeah, the whole chat, guys, effectively can mean whatever you want it to mean today. So just run wild with it, because I guess we don't have a definition anymore. Oh my gosh, crazy. So with that, that's kind of like the little rundown. I did see a small detail. 2 states. One of them was New Jersey. I don't remember the other state. I just saw it quickly, didn't look at it that much. Not a firearms person. But 2 states are suing Glock as a manufacturer for making it too easy to modify certain handguns, you know, and inside it said, like, for $20 you can apply a switch that fires 1,200 rounds, I think is what they said. So, you know, heard a lot about Glocks and switchies, thought it was interesting to see that lawsuit pop up today as well. But we're really here to talk about this effective, this effective sheriff's office and all that they do. So we're going to get into that. Big thank you to everyone being so kind in the chat. Thank you for the well wishes on hitting 30K, which is just incredible. No longer out here talking to myself or 3 people. We're all here together. FFS is making it rain out here. We have FFS gifting 1, 2, and then 5, so 7 from FFS. We haven't done a banner in a while, so let's get one of those going. And we don't have a squeak counter. We're going to say honey baked hams gifted today. We got 7 from FFS, so we'll get that going. I'll keep updating. Papa John, good to see you, says Merry Christmas, Cat Chat, and the mods. We got a Santa and we got Skull. Love it. Great combination there. Shout out to Vikings fans here in the chat. Destin to Be says congrats on 30K. Thanks so much, Destin to Be. People been sleeping on you. Well, thanks for being here. You're an early bird. You see that, guys? Destin to Be has been here for 6 months, which is a very long time when you consider how young this channel is. So show Destin to Be some love in the chat. SteffJK with the all caps says 30K, Cat, well deserved. Thanks so much. Good to see you, Steph. Renee Stevenson says, oh my god, hi Cat mods in chat. I don't get notifications when people go live. I'm so happy to be here for a live. Guys, I am excited to see how happy the whole chat is to see everybody. Like, a lot of people saying hi to each other. Like, finally, it's been like a week since we've had a live. So that's really, really good to see. Thank you for the 5 here, Renee. Sea Travel just showing love, been a member here for 4 months. Thanks so much. And interested viewer says the grand jury is supposed to inspect the jail. Interesting. Guys, what would you do if you were in a decision-making capacity to allow some type of thing to go forward against somebody, and that thing, you walk through and the conditions, the whole thing is in shambles, right? Wouldn't you just be like, do it, go forward? Let's see. I see what happened with Eppinger. I'm not sure there's been motion with Eppinger. He's, he's not one of the few that took a plea deal last week. And as far as I know, unless a plea pops up, if there's still negotiations underway, I don't really see that being the case for Eppinger in particular. But that deadline is supposed to be the 17th. Next week, by the way, I think on the 17th, Judge McBurney will have a bond hearing in front of Judge McBurney, who streams his courtroom. So I think that's Tuesday, right? So Tuesday we'll do a live, we'll get together, we'll check that out. Oh, did they have like a status or something? Interesting. Yeah, I'm not sure. So it was in Manning's courtroom. All right, this might be a long stream just because this complaint is 62 pages, you guys, and I don't like to just like skip giant chunks. Anything that's repetitious, like a cause of action that varies very slightly, once we get through one of them, we can kind of like blanket and go forward. But I still think this is going to be a good 40, 50 pages of substance that we can't just skip. So, heck yeah, Black Butterfly says on the 17th we'll be bopping around the multiple cases. Yep. And by the way, if you've heard me mention covering a Courtney Clenny hearing that was scheduled for tomorrow, it's moved to next Friday, so that's not happening. I might do the rewatch of her Arthur, which is like a bond hearing. We might do a rewatch of that tomorrow. It was pretty long. It's like 6 hours. So if you guys want to tune in, if I have time to do a 6-hour stream tomorrow instead of what was going to be probably a quick hearing, we could go and rewatch that. That bond hearing was from November of 2022. So if you're new to the Courtney Clenny case, a bond hearing is a great way to get context because it's kind of like a mini trial. So you'll hear a lot of what the prosecution's alleging, a good percentage of what evidence they have available, at least had at that point in time, and kind of see some of the early arguments being made. So if you're interested in the Courtney Clenny case but want a refresher, maybe we can do that tomorrow. But just know that if I'm not live at all, or if you see me live with Courtney Clenny but it's not a new status hearing, it's because it's been rescheduled to next week. So, yeah, right? Good Lord, she's never going to trial. Yeah, 2022, guys. We're about to be in 2025. And that's not like a RICO, that's one person waiting trial there. So, and thank you, Mix Chick, for the celebration here on the 30K. Very happy to have you here, and thanks for being a member for so long as well. Show Mix Chick some love in the chat. Yeah, I'm going to zoom in when we start reading, you guys. Thanks for the reminder, though, because you know how I do sometimes. Sorry for being muted before. But let's see. Let's get into the ooey gooey of this class action suit. There we go. And I think I can zoom in one more time. Well, maybe not. Will this cut off any words? All right, it looks like we've got the margins intact. And let me move my picture. I always think it works better at the top. Maybe not. Maybe down here? I don't know. Maybe down here works best. I'll be reading, so if I block anything, at least I'll read it. But again, guys, if you're joining late, this is federal, right? So this is being filed with the United States District Court. Again, the named plaintiffs so far are Nkenegen Hambrick and Shannon Stillwell Jackson. I love that little exchange with the attorney and the person asking the question on the video we just watched, where they're like, what is his real name? And they're both just giggling. But yes, Shannon Jackson has confirmed his legal name is Shannon Jackson. But again, since this is a class action complaint, if the judges accept what they're presenting as class criteria and decide, yep, we accept this class, you can move this forward, there are going to be unnamed plaintiffs, and there will be public notice filed as well as, mailed out to potential other plaintiffs that are unnamed to see if they want the opportunity to opt out of this class settlement. So a little bit of a different approach than a criminal case. But what are they essentially here? There's a common grievance or common grievances. And we know the target of this has to do with the jails. We've got Fulton County Sheriff Patrick Labat in his official capacity and the Fulton County Chief Jailer John Jackson in his official capacity. So what are the common grievances? So let's see. This is a nice chunky index here. And we'll get into these counts in detail later in, we'll see them come up when we get to that section. But we got to skip 3 pages there. That's kind of nice. So introduction. Plaintiffs respectfully file this complaint for declaratory relief, injunctive relief. And again, injunctive relief is, look, we're not just saying we're aggrieved and we want damages, right? They're also going to ask for damages, right? Maybe financial compensation for damages. But injunctive relief is so important. It's, these are the things that we're saying are wrong, should not be happening, or things that should be happening that are not. We want that to change. So court, you must compel Sheriff Labat and John Jackson to do the things they're supposed to do and stop allowing things that aren't supposed to be happening to continue to happen. We need that change. So they want declaratory relief, injunctive relief, and damages on behalf of themselves and a class of similarly situated individuals who have suffered or will suffer injuries because of defendants' deliberate indifference to the known excessive risk to the health and safety of detainees at Fulton County Jail, address 901 Rice Street at Northwest Atlanta, Georgia, which violate the detainees' rights under the 8th and 14th Amendments of the United States Constitution. 1, this is an action to protect people detained in Fulton County Jail, and they list Rice Street again. They're just going to keep calling it Fulton County Jail, from serious harm by the cruel and unusual conditions of confinement at Fulton County Jail. 2, this is an action of damages for damages to people who've been or in the future will be detained in Fulton County Jail and have suffered damages that arise from defendants' deliberate indifference to the known excessive risks to the health and safety of detainees at the Fulton County Jail. 3, Fulton County Jail detainees are at constant risk of danger, serious potential injury, and death due to Fulton County's crumbling infrastructure, which inmates use to craft makeshift knives called shanks for use as weapons. And again, this is not some, oh, we're so scared that something could happen and it's unfounded. We know that people have died here because of the conditions here. So it's not just a reach. Right? There's no saying that this is a reach. They have a whole DOJ report to rely on that found violations, civil rights violations. 4, Fulton County Jail detainees are at constant risk of danger, serious personal injury, and death due to Fulton County Jail's failure to restrict access away from parts of the jail containing readily available materials for crafting shanks. 5, Fulton County Jail detainees are at constant risk of danger, serious personal injury, and death due to defendants' failure to perform maintenance to remediate or replace non-working and dysfunctional jail cell doors that can be manipulated by inmates to enter or exit jail cells without authorization. And, you know, there's a link. You can go back and watch the stream where we went through that DOJ report. But offhand, I believe one of the statistics for one of the zones was that less than 5% of the locks were functional. Less than 5%. So, like, it's not just like, oh, one person put in one work order and that work order got, like, lost in the sauce and we didn't fix that one problem out of 1,000. No, the greater vast majority of non-functional, broken locks were not fixed even after a time period had gone by. Like, just incredible. 6, Fulton County Jail detainees are at constant risk of danger, serious personal injury, and death due to defendants' failure to use correctional practices such as classification, housing plans, assessment of the likelihood of victimization, and consideration of gang affiliations to manage the incarcerated population and reduce the risk of violence. So we kind of saw, if you looked at one of those interviews, I think it was DJ UTV, Woody did an interview on, and he was talking about when they held him in contempt, they tried to put him in certain areas where it would be especially problematic for him. And they should be aware of that. And when you're actually staying there for a longer period of time, right, that was contempt for over a weekend. But if you're not doing the proper classification and planning where you're going to house certain people, you're putting people at risk, right? You're failing to protect people by separating them proximally from people that would be inclined to start physical altercations with them. Fulton County Jail detainees are at constant risk of danger, serious personal injury, and death due to defendants' inadequate parasite and pest control. This is so disgusting. You're going to hear, I'm sure we're going to hear about LaShawn Thompson as an example. Rest in peace. LaShawn Thompson was an inmate. He was having some mental health concerns, and I really don't believe that it was chronic. I think it was acute, and it was something that was starting because he was in an infested jail cell in Rice Street. And one person was like, I don't think this is good. We got to do something here. And they never did anything. And he was found dead, being eaten by parasites, including bed bugs. Right? So again, this is not a situation where, oh, it's gross and I don't like it. There's cases where it's so gross that somebody has actually lost their life because of it. There is no, it's just a hypothetical. It's real. But yeah, so one of the grievances is the inadequate parasite and pest control measures, inadequate chemical control measures. We had some issues with bleach exposure, their failure to remedy unclean and unhygienic jail living conditions, and insufficient and nutritionally inadequate food. 8, Fulton County jail detainees are at constant risk of danger, serious personal injury, and death due to defendants' failure to staff and train the Fulton County jail detention officers and staff to protect detainees from attacks by other detainees. Does this ring a bell anywhere? Number 8? Anything, the response time from a video that we watched in the YSL trial relating to Rashawn Bennett? 9, gross deficiencies in Fulton County Jail's provision of medical and mental health care expose detainees to an increased risk of injury, serious illness, pain and suffering, mental health decline, and death. Fulton County Jail incident reports and medical records acquired from Fulton County Sheriff's Office via open records requests demonstrate long-standing, pervasive, and well-documented dangers of serious bodily injuries and death caused by the use of shanks in attacks between rival detainees, by detainees popping open cell doors to exit their cells without authorization, and to enter rival cells to perform attacks, by the unsanitary conditions, by detention officers' use of excessive force, and by Fulton County Jail's failure to provide medical treatment for illnesses and injuries. If you go back and look at that report, they do go into detail about one specific example where somebody was attacked, they were stabbed with a shank, and they just had him for like hours and hours, like overnight, before they took him to get stitches and get cleaned up. Like, just crazy. 11, under the 8th and 14th Amendments are constitutional protections. A jail must protect detainees from known risk of serious injury and death. In July 2023, the United States Department of Justice opened a civil rights investigation into conditions in the Fulton County Jail under the Civil Rights of Institutionalized Persons Act, the Americans with Disabilities Act, and the Violent Crime Control and Law Enforcement Act. On November 14th, 2024, so there's your date. I saw the chat. When did that report come down? That was November 14th, so we're 2 days away from being a month ago that this DOJ report came down. 105-page report titled Investigation of the Fulton County Jail, describing an extensive investigation into Fulton County Jail and results, determinations, and recommendations for change. The Department of Justice report is attached here within as Exhibit A. So that's not actually attached here. But if you want to check that out, there's a video about it in the description with the documents link there. 14. From its investigation, the Department of Justice found reasonable cause to believe that Fulton County and the Fulton County Sheriff's Office violate the constitutional and statutory rights of people incarcerated in the Fulton County Jail. The Department of Justice determined that Fulton County Jail fails to adequately protect incarcerated people from the substantial risk of serious harm from violence, including from homicides and stabbings by other detainees, and due to its failure to use correctional practices such as classification, housing plans, assessment of the likelihood of victimization, and consideration of gang affiliations to manage the incarcerated population and reduce the risk of violence. And they keep citing to this DOJ report. The DOJ determined that Fulton County Jail living conditions do not meet basic constitutional standards. The DOJ determined that jail deputies and detention officers use force against incarcerated people without adequate justification. Again, they're citing to this DOJ report, and if you didn't get to see it, it's more than just statistics. They do go into specific instances, details where deputies attacked one man who was seated with his arms crossed and claimed that they were fearing that he was going to lunge at them and harm them. Right? So they give more examples than just that one instance. But this DOJ report, I gotta applaud it because it didn't just put together a bunch of numbers. There's limitations in the way that things coming down from the DOJ can be written. But I swear, whoever worked on writing that report pushed to the limits to make sure they could tell the story. Give you a feel, even as a reader who's not physically there, an idea of just how bad the conditions are and just how bad some of the scenarios, some of the actual examples really were. So the Department of Justice determined that medical and mental health care in the Fulton County Jail does not meet constitutional standards. The DOJ determined that restrictive housing conditions in the jail pose a substantial risk of harm, including acute mental illness and self-injury, and restrictive housing practices are discriminatory and unlawful. They determined that the jail's grievance system does not offer incarcerated people an adequate way to report and avoid danger. Yep. Oh, just go use the kiosk and file a report. Well, the kiosk doesn't work. So, dead end. There you go. And jail staff improperly avoid investigating and substantially responding to detainees' grievances, missing opportunities to address unsafe conditions. DOJ found that the leadership at Fulton County and the Sheriff's Office are aware of the violence in the jail and have publicly decried it. Oh, I like this paragraph. But they failed to take adequate action to address the crisis, and homicides, the stabbings, and other violent acts continue at dangerous levels. So they know, and they've decried. This is such a great word choice. They haven't addressed it publicly. They've publicly decried it, but they're doing nothing. So, good little use of a word here. Plaintiffs expect to show that defendants' failure to implement and execute policies or procedures to limit or eliminate handcrafted shanks violates the 8th Amendment and 14th Amendment to the U.S. Constitution. Plaintiffs expect to show. Plaintiffs expect to show that defendants' failure to implement and execute policies or procedures to remedy non-working or dysfunctional cell door locks violates the 8th Amendment and 14th Amendment of the United States Constitution. Plaintiffs expect to show that defendants' failure to use correctional practices such as, this is going to repeat itself, but they're saying that each of these things that we're saying is wrong, and that the DOJ has substantiated as, yeah, we did this investigation, also found that these things are wrong. Plaintiffs are saying, we expect that we have the evidence to demonstrate that these things are wrong the way we say they are, right? So they expect to show evidence about the classification and housing plans not being done right. They expect to be able to show that the failure to implement and execute policies and procedures to get rid of these pests, the sanitation issues, the hazardous conditions, we have evidence of that. And I think if you've just scrolled through to look at the pictures of that DOJ report, kind of self-explanatory. Plaintiffs expect to show that defendants' failure to train detention officers to prevent the unauthorized use of force violates the 8th Amendment and 14th Amendment. We're going to be able to show that they failed to provide adequate medical care. We're going to be able to show that the failures described above, and this is big, are the cause in fact for detainees' exposure to serious bodily harm and death. It's causal relationship. It's not like, oh, these conditions are bad, and sure, you have a grievance about them, and people may have died, but the death was unrelated. No, plaintiffs expect to be able to prove, to show evidence that the deaths and serious bodily harm, the conditions that are being inflicted upon these individuals here in this jail, is being caused by these conditions, these failures. Plaintiffs expect to show that defendants' failures described above are the cause, in fact, for plaintiffs' injuries, entitling the lead plaintiffs and class action plaintiffs to an award of damages. Plaintiffs expect to show that defendants have been deliberately indifferent to known risks of serious harm and death to detainees at Fulton County Jail. Plaintiffs expect to show that defendants know of and are consciously disregarding excessive risk to the health and safety of detainees at Fulton County Jail in violation of the 8th and 14th Amendments to the United States Constitution. And again, we're saying that they've decried publicly. We know these conditions exist. Well, it's going to be pretty easy to demonstrate that we know you're aware of them and you know that these conditions are there. The lead plaintiffs bring this action on behalf of themselves and similarly situated individuals for declaratory relief, injunctive relief, and for damages due to defendants' deliberate indifference to the excessive risk to the health and safety of detainees at Fulton County Jail, and to vindicate detainees' rights under the 8th and 14th Amendments of the U.S. Constitution. Now, jurisdiction and venue. Why is this a federal case? Why are we taking this to a federal level? All right? Well, on its face, an obvious answer would be there's issues of constitutional violations here. So, this court has jurisdiction over this action under 28 U.S.C. 1331 because it raises claims arising under the U.S. Constitution and the Rehabilitation Act of 1973 and Title II of the Americans with Disabilities Act of 1990. So, some federal statutes here, acts. The Atlanta Division of the Northern District of Georgia is the proper venue because all defendants are Georgia residents and at least one defendant resides in the Atlanta Division of the Northern District of Georgia. And under 28 U.S.C. 1391b2, because a substantial part of the events or omissions giving rise to the claim occurred in the Atlanta Division of the Northern District of Georgia, right? They're not going to, hopefully the defendant doesn't try to come out and be like, we don't really think that jurisdiction's proper because, what does it have to do with this Atlanta area? Parties. And this is going in front of a federal court and a federal body, right? The DOJ is the one that's saying there's violations here of the 8th and 14th Amendment. So, my jaw would drop to the floor if this court is like, we don't think you have jurisdiction because we don't really find at a, prima facie level that this rises to, an issue that we should have jurisdiction over. The DOJ has kind of already said it. The parties, again, this complaint's filed on behalf of the plaintiffs and where applicable and or necessary. This complaint is also filed on behalf of plaintiff spouses, children, parents, decedents, wards, heirs, and or legally designated representatives. So, covering all bases here. Plaintiffs in these individual actions are citizens and or residents of the United States who've suffered acute personal injuries, acute psychological suffering or mental anguish, or death because of defendants' deliberate indifference to the known excessive risks to the health and safety of detainees at the Fulton County Jail. So now we're going to get a little more background on the plaintiffs as parties, the named plaintiffs. So, and did we get a name spelled wrong here? There was an extra E earlier, wasn't there? So maybe I'm saying it wrong, but Nkenegen Hambrick is a 44-year-old male. Shannon Jackson, aka Shannon Stillwell. Oh my God, are we going to hear Michael Harper say my name is Michael Harper and I represent Shannon Jackson? He was born in 1992 and is male. The conditions under which a convicted inmate are held are scrutinized under the 8th Amendment's prohibition on cruel and unusual punishment, and the conditions under which a pretrial detainee are held are reviewed under the Due Process Clause of the 14th Amendment. Pretrial prison conditions may not be imposed to punish a pretrial detainee, and impermissible punishment may be inferred if the prison condition at issue is not reasonably related to a legitimate goal, if it is arbitrarily purposeless. Makes me think of those plea deals. A valid prison conditions claim has two components. One, an objective component which requires that conditions be sufficiently serious. And two, a subjective component which requires that prison officials exhibit deliberate indifference to prisoner health or safety. So, we've got to meet these two factors here, right? The conditions have to be bad, and we've got to be able to weigh, at least in part, there's some deliberate indifference. We know about it. We're not doing anything about it. We don't really care. The punitive class includes individuals detained at Fulton County Jail who have suffered acute personal injuries, acute psychological suffering or mental anguish, or death because of defendants' deliberate indifferences to the known excessive risks to the health and safety of detainees at Fulton County Jail, which do not serve a legitimate goal, including, but not limited to, the known hazards arising from handmade shanks, or the known hazards arising from non-working or dysfunctional cell door locks, or the known hazards arising, am I going to run out of fingers? The known hazards arising from defendants' failure to use correctional practices such as classification, the housing plans, assessment of the likelihood of victimization, and consideration of gang affiliations. Or the known hazards arising from filthy, vermin, and parasite-infested, unsanitary jail conditions. Or the known hazards arising from unauthorized use of force by Fulton County Jail detention officers. All right, I didn't run out of fingers. The known hazards arising from inadequate provision of medical care, including mental health care. The conditions described in the preceding paragraph are sufficiently serious because they deprive detainees of the minimal, civilized measure of life's necessities, or otherwise pose an unreasonable risk of serious damage to health and safety. And they're citing here Chandler v. Crosby, which is quoting Helling v. McKinney, and Rhodes v. Chapman. So we've got some federal cases here. These are U.S. cases. We're not coming to play here with the case law. And guys, if you are familiar with that DOJ report, is this agreeable? Is this agreeable to call the conditions described sufficiently serious because they deprive detainees of the minimal civilized measure of life's necessities? You need food, you need water, you need shelter, you need hygiene. You need safety from someone that's trying to shank you. I feel like all of those are missing. So, crazy, crazy, crazy. And thank you guys. So much love in here. You guys are so nice. I see Flesh of the Gods stop by. If you're still in here, good to see you. I think, hold on, is Thursday one of the nights you go live? I know if SteffJK is in here or FFS, I know they'll already know before I can look myself if Flesh of the Gods is going to be live tonight. But I'm excited. If you are, I'll come hang out. And Flesh of the God says, peace, peace, family. Hoping all is well always. Big thank you. Interested viewer, and I love this name. 2020 Georgia Code Courts, 12 juries, $4 grand, part, and 15-12-71. Duties of grand jury. Why was it so bad? Let's see. I think $4 grand, that's their calendar, right? Right, isn't that like they have like 4 calendar segments each year? Here, fill me in, but you don't need to super chat. Did you want me to pull this up and look at it? Because we can if you want to. Just let me know. 2 souls for you says, this is so nice. Merry Christmas, Cat Chat, and the mods. We've got, I think, a Mr. Claus, a Mrs. Claus, and then maybe, is there a baby Claus emoji? There's 3 there. I was about to go a different direction with it until I looked closer. Thank you, 2 souls for you. Good to see you. Bees on Mars says 30K in my kattnotwilliams voice. Holy moly. Heck yeah. Thanks for being here for 4 months, Bees on Mars. Violet says, I'm a proud member of KNW's Slime Gang. Hey, I never put that banner up. Never put this banner up. We're counting the honey baked hams. Oh, it's not a scrolling banner? Let's get some, there we go. We're giving out the honey baked hams today in the chat in celebration of somebody, I guess a group of people, suing about the jail conditions. It's great to see. Gina Semino says, I loved your confrontation with Juror 409. They need some 409 in this Rice Street facility. Like, spray it down. Missed you too. I know, everybody was like, you should go live. As soon as we had the trial and I knew we'd have a week of, some happening, some motion, with potential pleas and what's going on with the next case. But after that, I booked up so much work. I've been working day in and day out. So I just haven't had the time to go live. So it's been weird. It's been really weird without you guys. And after that Juror 409 interview, everyone's like, can you go live so we can decompress? And I just couldn't do it. I couldn't make the time for it. So my bad on that, you guys. But thanks for all the love. NJB says, I'm proudly a KNW slime member too. Heck yeah. Hashtag Mlat and hashtag no slime left behind. That's right. Chloe Albert's Revenge says, so wait, this wasn't an appropriate place for the state to stash their kidnapping victims either. No, probably not, Chloe. And Nem says, ode to Kat, baking cookies and cooking jurors. Heck yeah. Those cookies are gone, by the way. I don't know why Dennis thought I would just hold them hostage, hanging around for 2 weeks and not eating them. This interview was on Dennis Byron's channel. It was part 3, was the interview where I jumped in, unprepared, which is why I'm mentioning cookies, because I was in the middle of baking. It was probably covered in powdered sugar. But yeah, so. Yeah, April O'Neil's baby daddy, exactly this, says housing high-profile defendants and or rival gangs together is wild. You might even say it could be strategic rather than careless, right? You know. And all they need to rise to is deliberate indifference. But if you have extra evidence showing that they did certain things on purpose or at like convenient times that would suggest strategic. Yeah, and Grace is saying it could be members only now. Yeah, I don't really know. I mean, I could pull it up and see. I think it's still live. So this would be the link. So drop that in the chat there. And I should actually rewatch that because I jumped in on that on my phone, so I couldn't really see comments or feedback from you guys. But I should go and rewatch that. I was like, you know, I don't really like to argue. And I also am not prepared to, I've never used StreamYard on a cell phone. I didn't really know what I was doing. So it was a bit of a, I couldn't do 2 things at once in that moment. But there you go. It's linked in the chat for you there. Renee Stevenson, thank you again. Congrats on the 30K with the amphibious green snake emoji. Thank you so much. And then, let's see. React to my own interview, that guy, Nick. No, I'm gonna get a strike. Let's not do that. Let's not do that. And then, let's see. Peter Ortiz, good to see you. Hope you're doing well. Hope your finger has fully healed, because we need some nose wiping going on. Thank you for the super here, and good to see you. And I wasn't so much trying to hold back in that interview with Juror 409. I didn't want to like go lash out at anybody, and I never would. I never would want to be of that approach. But it was like I had to remember not to forget my point. So there were parts in time where she would go so far off subject and not listen to what I was actually saying, right? That I would just have to sit and wait and try to listen to what she was saying so I wasn't missing it, while also not forgetting the thing that I initially asked. And that was really hard to do. It was really hard not to completely be thrown off course. So, but yeah, you guys can check that out. I'll drop the link again, and then I'm going to close this window I have open over here, and we'll get back to reading this suit. I'm just going to call it Juror 409. There's a link in the chat. Nem, you're going to give me flashbacks that I don't want to have. Like, I didn't say anything about the tint. I didn't say you said anything about the tint. Well, let me talk. But you're talking as if I said you said something about the tint, and this is why I don't do arguments. But yeah, you guys can go check that out and understand what we're talking about if you don't already know. That is a alternate juror that, at least in her first interview, she says she changed her mind now, kind of, somewhat, sort of. Said she would have hung the jury if she went in there to deliberations. So, let me close that window, because sometimes YouTube, it just messes with StreamYard. Makes me laggy. But let's get over here. So what about the defendants, right? Still talking about the parties here. And defendant Patrick Labat is sued in his official capacity as the sheriff of Fulton County, Georgia, a position he's held since January 1st of 2021. Defendant Labat is the chief executive of the Fulton County Sheriff's Office. He's responsible for the day-to-day operations of the Fulton County Sheriff's Office, including the Fulton County Jail. As sheriff, he's required by Georgia law to operate the Fulton County jail system, to maintain the custody of people held in his jails, and to ensure safety and sanitary conditions of confinement. You think he's doing that? And the thing is also, guys, remember, if you've paid attention to some of these press conferences or these Fulton County Commission meetings where they're asking for more funding, there's an acknowledgement that precedes that request for funding. Hey, we can't do enough. We don't have the resources. We don't have the money. We don't have the human power, right? We don't have enough staff. So we need more funding. So in these public requests and these other press statements describing why we don't have enough funding, there's been an admission that we know the conditions here are staffing. It's not adequate, right? So, I mean, how do you say that you said those things when you're asking for funding, but now that there's a class action suit in front of you, it's going to be an interesting thing to see the defendants defend themselves. Defendant Labat is a resident of Fulton County, Georgia. At all times relevant to this complaint, Defendant Labat has acted under color of state law. The Fulton County Sheriff's Office is a program of entity receiving federal financial assistance. John Jackson is sued in his official capacity as chief jailer for the Fulton. That is not a title I'd ever want to have for the Fulton County Sheriff's Office. Under the Fulton County Sheriff's Office Jail Operations Standard Operating Guidelines, they've got a chapter, Safety Subject, Sanitation Procedures, Inspections, and Housekeeping Program, effective February 2nd, 2022. So this is new. It's not like some old thing under the rug that we forgot about. Also Section 7, the chief jailer shall appoint a fire safety and sanitation supervisor and fire safety and sanitation officer who are collectively responsible for coordinating, conducting, and documenting fire, safety, and sanitation inspections by independent agencies. At all times relevant to this complaint, Defendant Jackson has acted under color of state law. The Fulton County Sheriff's Office Jail Operations Standard Operating Guidelines, Chapter Safety, Subject, the same thing, effective on February 2nd, 2022. They're attaching it as Exhibit B. Now we get to the T, guys. Allegations of fact. And I love that they're wording it as allegations of fact because sometimes it will be statement of fact or factual basis. And, really when you're reading a complaint, even if it says statement of facts, it doesn't mean that these things are adjudicated as fact. They are allegations. It's what one party is alleging and why they're bringing their complaint forward, right? So I have an appreciation that they're using the phrase allegations of fact here because it's very confusing when lay persons, I had to learn this too, like the first time I started looking at complaints, reading them. Statement of facts seems confusing. Wait, these things are facts or are they allegations? I like this heading. But 1, despite the presence of written policies and procedures for safety, housekeeping, and jail management, Fulton County Jail presents obvious hazards to the health and well-being of its detainees. The main facility for holding Fulton County detainees is the Fulton County Jail, located at 901 Rice Street, Northwest in Atlanta. Fulton County Jail was built in 1989. Hey, that's only 2 years younger than me. Fulton County Jail has an operational capacity of around 1,900 people and has for many years operated at or above that capacity. Fulton County Jail consists of a 3-story, low-rise structure joined to an elevator tower, providing access to 2 housing towers. The North Tower has 7 floors for housing, and the South Tower has 6. Each housing unit has 8 zones arranged in a horseshoe around an elevated control tower. Remember, this is to be the panopticon effect, right? You can put less staff in a tower where they can see out and see more, and an individual on the perimeter might not necessarily be able to see if they're being seen at any given time. So it's a way to reduce staffing, which now ends up being problematic. The housing zones have between 16 and 18 cells, split over 2 tiers. The cells open into a day room with tables bolted to the floor, phones, a kiosk for ordering commissary and submitting grievances, among other things, and a shower on each tier. The primary entities responsible for the jail are the Fulton County Sheriff's Office, which operates the jail, and Fulton County Board of Commissioners, which funds the jail. The 7-member Fulton County Board of Commissioners is the governing body for Fulton County. Through the Board of Commissioners, Fulton County provides funding for the jail and maintains the jail facilities. The county sets funding levels for the sheriff's office, but the sheriff is an independent elected official. As stated above, the sheriff is required by Georgia law to operate the jail system, to maintain the custody of people held in his jails, and to ensure safe and sanitary conditions of confinement. Fulton County Sheriff's Office has adopted jail operations standard operating procedures, which are divided into chapters, and we looked at this. This is the sanitation, the inspections, housekeeping. They also have sanitation procedures, inspections, and housekeeping. Now, this one's a new one. This one's coming out in June 14th, 2023. It's not the one they talked about already. A new chapter, sanitation procedures, inspections, and housekeeping program under chapter safety. So they're adding new procedures, right? And this is, why are they laying this out? Well, you can't say you don't know what you're supposed to be doing, while in the same vein, you're rolling out new procedures, new policies, new standard operating procedures. So here in February 11th, 2024, we get new ones. Housekeeping, janitorial, laundry, and supply storage. We get June 13th, 2023. We're out of order here. It says facility inspections. Fulton County Sheriff's Office has adopted jail bureau policies and procedures, which are divided into subjects, including classification/security and indexes, such as classification of inmates, classification plan. So all of these things, we're still writing these things. We've adopted these things, but we're not doing them. So this is laying out the groundwork. We can't deny that we didn't know we were supposed to be doing this. Let's see, how much of this did they have? This is gonna go through a whole list of different policies. Defendant Labat has publicly admitted that he lacks the resources to carry out his legally mandated responsibility to protect the constitutional rights of pretrial detainees at Fulton County Jail. Again, this public acknowledgement, right? We don't have the resources that we need, but what precedes that when you're speaking publicly? We need to do these things. That's an acknowledgement that you know what you're supposed to be doing. And kind of you can draw the inference that we're not doing those things because we lack the funding. I don't envy the attorneys that come in and have to find an argument here, right? Have to provide a defense for this. The risk of harm arising from the presence of handmade shanks, non-working or dysfunctional cell door locks, unsanitary bug-ridden conditions, and excessive use of force by detention officers is a long-standing and ongoing reality for detainees at Fulton County Jail. Defendant Labat has explained to the Fulton County Board of Commissioners and to the general public on multiple occasions. We got 3 years. So in 2021, in 2022, and 2023. So it's not just a fluke, right? We're doing this throughout the whole ebb and flow of any changing conditions or populations in the jail. Why there is such a proliferation of homemade knives and shanks at the Fulton County Jail. Detainees at the jail fashion metallic weapons from the crumbling physical infrastructure of the jail. And this is something we heard about before the DOJ report came down, but the DOJ report confirms it. That gives it a major, major level of credibility. In the fall of 2021, Defendant Labat gave the Fulton County Board of Commissioners a tour of the Fulton County Jail. The tour allowed the commissioners to observe firsthand the deteriorating infrastructure at the Fulton County Jail, which infrastructure was and still is being used by inmates to fashion metallic knife-like weapons called shanks. On or about April 20th, and that's always sucks, right? You get a typo, but the typo is like another word, so it doesn't register as a typo. Knife life. On or about April 20th, 2022, a sweep of the Fulton County Jail resulted in the discovery of nearly 100 knives or shanks. In a dramatic and well-publicized appearance before the Atlanta City Council on October 3rd, 2022, Defendant Labat had a jail guard roll a wheelbarrow full of shanks confiscated from the Fulton County Jail into the Atlanta City Council chambers. I don't know. Have I seen this? I think maybe Flesh of the Gods may have played this on his stream. That might need to be a thumbnail. If anyone else in the chat is going to do a stream on this, please make your thumbnail the wheelbarrow full of shanks confiscated from this jail. Oh my gosh. And again, the point of all of this is you can't deny that you knew these things were a problem when you're showboating it. You're decrying it. In a mid-July 2024 news conference, defendant Labat stated that since June 1st of 2024, there had been 10 stabbings at the jail and that 75 knives and shanks had been confiscated. So that was about a month and a half time frame there. Defendant Labat has, over a period of several years, repeatedly and vociferously decried the lack of Fulton County allocated funds for urgent jail priorities, such as inmate security, upkeep of deteriorating jail facilities, and staffing. On July 21st, 2023, representatives of the National Institute of Corrections, the U.S. DOJ, and the Bureau of Justice Assistance. Now, the BGA is where a lot of these funding that we've talked about for like gang prosecutions and clearing the backlog, a lot of that has originated out of BGA, right? So that might seem particularly familiar in a different way than the DOJ, because it's had a big part of the conversation here when we talk about YSL and RICO prosecutions. This site visit resulted from a September 20th, 2022 request from defendant Labat to the National Institute of Corrections for Technical Assistance. So he's waving down the cars like, come look at this, come help. Defendant Labat informed the NIC and BGA representatives that during his term, thousands of homemade knives made of material from the deteriorating facility have been confiscated at the jail. Labat also informed the NIC and BGA that detainees often fashion weapons when they do not feel safe. Defendant Labat advised members of the site visit team that the number of uniformed staff vacancies in the jail was at a critical staffing shortage level. According to Labat, a housing floor at the jail should ideally have 2 officers in the housing control room, as well as 3 officers who constantly move through the 6 housing zones, providing safety and security tours, making inspections, and managing the people detained within the zones. According to defendant Labat, in practice, there is typically only 1 officer in the housing control room, and at most, 1 officer moving through the housing zones, with nearly 200 detainees. As stated above, the DOJ launched an investigation into the Fulton County Jail on July 13th, 2023. We went through a lot of this stuff. It's going to repeat. They went through, they found these things that were wrong. Insects, unsanitary living conditions. And here we go. Summarizing the reasons for the DOJ investigation, Attorney General Merrick Garland stated, "We launched this investigation into the Fulton County Jail based on serious allegations of unsafe, unsanitary living conditions at the jail, excessive force and violence within the jail, discrimination against incarcerated individuals with mental health issues, and failure to provide adequate medical care to incarcerated individuals." Ryan Buchanan, United States Attorney for the Northern District of Georgia, joined Attorney General Garland, providing his view of the justification for the DOJ investigation, stating, "The recent allegations of filthy housing, teeming with insects, rampant violence resulting in death and injuries, and officers using excessive force are cause for grave concern and warrant a thorough investigation." According to Assistant Attorney General Kristen Clark, the DOJ's ongoing investigation of the Fulton County Jail revealed that at one point in 2022, more than 200 weapons were discovered during a sweep of the main jail. Condemning the Fulton County Jail, Kristen Clark said, "The unconstitutional conditions that we see too often inside jails and prisons have no place in society today. Our investigation into these matters is guided by one core principle. People held in jails and prison do not surrender their constitutional and civil rights at the jailhouse door," Clark said. And I appreciate her for saying jails and prisons, because we have a lot of focus, and rightfully so. I'm not trying to minimize the focus on jails, but jails we've been talking about, these are people there for pretrial detention. They haven't had their day in court. They're not convicted. They're still waiting their day in court, and they're living in these conditions. But I appreciate that Clark is saying, hey, this isn't okay to do in prisons either. Post-conviction, right? That's still not okay to have these types of constitutional violations, civil rights violations, right? I'm glad that this was broader than just jail. According to Clark, 87% of the jail population in Fulton County is Black, and the vast majority have not been convicted. They are awaiting bail hearings. They don't even have a trial date. Competency evaluations and restoration services, or are detained because of their inability to post bail. And remember, I think it's on hold right now, but there's a separate, it's statewide, right? I think it's blocked by executive order in the short term, but they're still trying to, I gotta catch up on that. But nonprofit organizations that help people that are granted bond but can't actually post anything, right? There's nonprofit organizations that raise money to post payments, right? Put up the cash bail so people that are granted, the opportunity to get out while they await their trial can actually go home and not just be stuck because they can't afford. And sometimes these bail amounts are like $900. But there's something that happened that's trying to cap the amount of individuals that a nonprofit organization can help within a calendar year to 3 individuals. And what's crazy is I would love to live in a world where we only need to post, and maybe there's 5-10 nonprofits. They can, at capacity, handle like 30 bail cases per year. They can post 30 bails. But that's not really the case. We're talking like hundreds of people that can't afford their bail, even though the bail is under $1,000. The ACLU put together a whole report on this. It's one of the first videos I did about Fulton County on this channel. But you can look at that information if you look up the Barred Business. That's a nonprofit that's trying to, help with some of these initiatives. And ACLU attorneys helped them. They're representing them in, I think it was just a writ of mandamus, right? They filed a writ of mandamus to request the Georgia Supreme Court to order Fani Willis, hey, if there's people that have been waiting for an indictment for more than 45 days, make her send a note to the chief judge, Judge Glanville, notifying him that, hey, we still haven't indicted somebody, even though we're statutorily obligated to do so. We still haven't done it, so you should set a bond hearing, right? Their whole interaction was to put this writ of mandamus forth to ask the Supreme Court to ask Fani Willis to do what she's supposed to be doing anyway. But if you want to look at that, just look up Barred Business, BARRED, ACLU, writ of mandamus or lawsuit, and you'll be able to read that. After this stream, I'll update this description and I'll add it to the description. But it was really interesting stuff. They went through the statistics on the amounts that were set for bail, that people were they couldn't afford it. And the amounts are, in the majority of cases, below $1,000. So, DOJ investigators reported credible allegations that inmates of the jail are housed in a facility considered structurally unsafe, and that correctional officers are using excessive force, and that violence is widespread, resulting in serious injuries and murders. The proliferation, okay, we're going to a new section. I'm reading it like a paragraph, but whole new section here. The proliferation of shanks, detainees popping open locked doors, incidents of violence, failures to appropriately classify detainees, and unsanitary living conditions at the Fulton County Jail continues unabated. The DOJ's November 14th, 2024 report states that 3 months after a detainee's arrest, that detainee died in a filthy cell in the mental health unit of Fulton County Jail. 3 months. A medical examiner reported that his malnourished body was infested with an enormous presence of body lice, and concluded that he was neglected to death. Now, when you are quite literally a ward of the state, you are in custody. If your body's infested with vermin, is that something that you can blame on this individual? The DOJ's report identified a NAFCARE report that found that every person in the mental health housing unit, meaning about 100 people, had lice, scabies, or both. And I don't know if they'll get into this, But the DOJ report talks about how during intake, they're not even following the standard procedure to do like a look down, have people shower. They're not doing those basics, which seems like a recipe for bringing things in that you don't want in here. 100 people had lice, scabies, or both. An infection control report documented 204 ectoparasite cases in the jail, and there were also outbreaks in preceding months. 36 ectoparasite cases in June 2022, 151 in July 2022, and 55 in August of 2022. Both medical and custodial staff were aware of the extent of the issue. As the infection control reports were shared at meetings, both medical and custodial leaders attended. So you knew about it. Ugh, gross. Gross, gross, gross. In 2023, defendant NAFCARE announced that it planned to terminate its contract because of violence and unsafe working conditions in the jail. Ultimately, the dispute was resolved and NAFCARE remains the current healthcare provider. Open records request to the Sheriff's Office for Jail Incident Report demonstrates the prevalence of shanks and cell doors that can be popped open as recently as August 24th, 2024. A jail incident report dated August 24th memorializes an incident wherein a detention officer discovered a cell door tampered with and open, and learned from a detainee that the detainees in that cell had burned a hole in the cell door and then popped the cell door open just prior to lockdown. How do you not smell that? I mean, that could just go back to the, lack of staffing, but, that seems like that would kind of, throw a smell, right? It would travel somewhat. I don't know, the smell of anything burning, I feel like, carries. Oh my gosh. Upon searching the cell, detention officers discovered various metal sharp-like objects on the top bunk and inside the light fixture, and a piece of concrete stuffed inside a sock. One of the residents of the cell claimed ownership of one of the shanks, claiming it was for his protection. Now, the trouble with this is it's like, you're not supposed to have this thing, but if you have to have this thing, now you're damned if you do, damned if you don't. You either don't have this thing or you have this thing, and you can survive a little bit more, you can protect yourself, but you're going to get in trouble for having the shank. Other shanks went unclaimed. 2 of the shanks had burn marks on them, indicating that they had been used in burning the lock. The August 24th, 2024 jail incident report is attached as Exhibit G. A jail incident report memorializes an incident on August 12th, 2024, when a detainee hid 5 handmade shanks under his clothes and told detention officers that the reason he has shanks is for protection against others. Inmate Smith also stated he has more where that came from, and he can buy more. Inmate Smith is like, all right, if I'm not supposed to have them, take them, but I'm going to get more. A subsequent search of inmate Smith's cell uncovered a shank underneath the mattress and other contraband items. The August 12th, 2024 jail exhibit is attached under Exhibit H. I don't think they've attached those because they've mentioned exhibits that would be way too long to be... Yeah, so those aren't attached, unfortunately. And I should have looked at what page I was at. My bad. Well, let me just look for Smith. Oh, it's not searchable. It's not OCR'd. This document. That's why I can't highlight anything or circle anything as I'm reading it. I should have done that before I did the stream, but I didn't realize. But I can't search it right now either. Let's see. No, we were way further than this. Okay, we're close to it. Yeah, there we go. So, a jail incident report dated August 10th, 2024, memorializes deliberate indifference to the health and safety of an LGBTQ detainee. On August 10th, 2024, Tower officers reported to a detention officer that detainees in Zone 5 South were not happy with an LGBTQ man in the zone. The detention officer found detainee Jones standing by the phones. The detention officer explained to Zone 500 that they can't dictate who can and who can't stay in the dorm. As the detention officer was exiting Zone 500, a detainee Jones rushed out of the zone door while stating that he was not effing staying in here. The detention officer then used her taser on detainee Jones. The August 10th, 2024 jail incident report is attached here too under Exhibit H. And I think the purpose of this is they can do some zone mapping, right? I think that's the point here. I don't really think so instead of doing zone mapping and keeping the two parties separate, right? Because this person that's running around, maybe he has some concern, or maybe he's going to offensively do something to the other individual. Do the mapping, reclassify how you're zoning people. But instead, they're saying, oh, we can't do that. I'm just going to tase you for acting up. The Jail Bureau Policies and Procedures for Classification of Inmates. Oh, I could have kept reading. Classification Plan, effective May 18th, 2006, states, the classification system is used to separate inmates into groups that reduce the probability of assault and disruptive behavior. At a minimum, the classification system evaluates the following: medical and emotional stability, and the need to keep separate. So there you go. Yeah, definitely highlighting, we can't make any changes. You know, you actually can. It's like spelled out here. The Jail Bureau Policies and Procedures for Classification of Inmates, Classification Plan, effective May 18th, 2006. The housing zones are double bunked, except for the 6th and 7th floors of each tower, which are single bunked. Under the authority in Farmer v. Brennan, a case involving a transgender inmate, if an Eighth Amendment plaintiff presents evidence showing that a substantial risk of inmate attacks was longstanding, pervasive, well-documented, or expressly noted by prison officials in the past, and the circumstances suggest that the defendant official being sued has been exposed to information concerning the risk, and thus must have known about it, then such evidence could be sufficient to permit a trier of fact to find that the defendant official had actual knowledge of the risk. So we've got some standing here. They're citing Farmer v. Brennan here. The question under the Eighth Amendment is whether prison officials acting with deliberate indifference expose a prisoner to a sufficiently substantial risk of serious damage to his future health. Now, this is not, did we expose you to harm? This is risk. Did we expose you to a sufficiently substantial risk of serious damage? We don't need to get to, we exposed you to damage that actually occurred. So, the August 10th, 2024 incident report concerns an LGBTQ detainee being openly harassed by detainees in a double bunked zone. You can probably see where they're going to go here. The detention officer's meager explanation to all detainees in that zone that detainees cannot decide who is in their zone is clearly non-compliant with the Jail Bureau Policies and Procedures for Classification of Inmates, Classification Plan, effective May 18th, 2006. Because it shows deliberate indifference to a demonstrated probability of assault and disruptive behavior expressed by the detainee victim and detainee aggressors. Under Farmer v. Brennan, a trier of fact may find that the official had actual knowledge of the risk and then acted with deliberate indifference, exposing the LGBTQ detainee to a sufficiently substantial risk of serious damage to his future health. In response to the detention officer's deliberate indifference, the LGBTQ detainee rushed out of the zone, seeking safety, and was tased by the same detention officer. Defendant's failure to remedy, this is a new section, defendant's failure to remedy the known hazards at Fulton County Jail is the cause of serious physical injuries, mental injuries, and death to Fulton County Jail detainees. So, it's the cause. It's not just something that was going on while somebody else had their own physical ailments, right? It's causing them. The experiences of lead plaintiffs, and other detainees in the jail described above illustrate the long-standing, pervasive, and well-documented risk. And it's so helpful, right? We know that there's issues with some of the one-off reporting. The kiosks aren't working. But we've got this documentation from Sheriff Labat. We've got this documentation because of walkthrough visits from other agencies. We've got this documentation. We've got this report by the DOJ. So, well-documented, yes. The well-documented risks of serious damage to detainees' health and well-being at the Fulton County Jail. The living conditions of the detainees at the Fulton County Jail directly contribute to the fear of detainees, deterioration of the mental health of detainees, and further escalate the violence. The defendant's failures set forth throughout this complaint and in the DOJ report directly contribute to the proliferation of violence at the jail. According to the DOJ report, within weeks of opening its investigation of the jail in July 2026, 6 more black men died in the jail. One person was found unresponsive in his cell after his cellmate strangled him, and days later, tensions in the jail cell erupted in violence. Within 24 hours, 5 units in the jail saw violent assaults, at least 7 people were stabbed, and 1 person was killed. On September 23rd, 2022, Dino, maybe it's Dino? That's a cool name! Dino Walker? Dino? It's probably Dino, but Dino Walker is cool. That's a cool name. And oh god, he was murdered by rival detainees. So my bad, I'm like tearing on his name, rest in peace. Was murdered by rival detainees wielding shanks at the Fulton County Jail. On September 23rd, 2022, at the time Dino Walker was killed, there was not a single officer moving through the 6 housing zones on his floor. The presence of a uniformed staff member or on the cell block deserted by uniformed staff on September 22nd, 2022 might arguably have discouraged the knife attack on Dino Walker, right? Presence of somebody for deterrence could have prevented this. And we've heard Sheriff Labat say publicly, he needs more staff. We're supposed to have this many, and we only have this many. So it's known. There's no denying that we're aware of it. On October 19th, 2022, Shamar McElroy was murdered by his Fulton County Jail cellmate, Jeremiah Collier. Jeremiah Collier was a known murderer with mental health issues. On or about, and this isn't really expanded, but I wonder if the idea here is, again, we didn't do the separation that we could have done. Or treat somebody adequately. On or about June 21st, 2022, Anthony Jenkins was murdered by his cellmate. On August 31st, 2023, Davion Blake, we heard his estate is bringing a separate lawsuit, a lawsuit separate from this one. Davion Blake was stabbed to death by rival inmates wielding shanks. In the month leading up to his death, Davion Blake had been on suicide watch, had been receiving medication for schizophrenia, and NAFCare medical professionals had released Davion Blake to general population after a brief stay in the medical ward. Oh, we might have to look at that. see what they're saying in that lawsuit. There's just this one paragraph. And again, there's a reason that the attorneys filing this case might want to write this in a way that would be favorable to what they're alleging here. But the idea that somebody was being treated for schizophrenia, it says in the month leading up to his death, he'd been on suicide watch and had been receiving medication for schizophrenia. From my layperson knowledge, anecdotal experience, knowing others that have dealt with an individual that needed to take some type of medication for schizophrenia, it's not something that you take and 4 days later you're back and ready to go. So I think just at face value, hearing that this time frame was a month or less, that they're putting him back in general population raises a big red flag to me. Just as a layperson, I don't really know for sure. In response to an open records request for dates of inmate deaths, as well as the cause of death at Fulton County from January 1st, 2018 to September 9th, 2024, Fulton County Sheriff's Office responded with the names of 44 detainees and their dates of death, but did not include a cause of death. If you're not looking at why people are dying, either they left it out even though it was requested, which raises an eyebrow, or they're not looking. And if you're not looking at a cause of death, what does that mean? You're not preventing it in the future, but you have a duty. You have a duty to do so. You have a duty to make sure you're protecting, the basic living conditions and future health of the people you're in custody of. So you're either not providing it, and that raises questions, or you're not looking for it, which is why you can't provide it, which is a big problem. The list of detainee deaths and date of death is attached herewith as Exhibit 1. Defendant Labat has been aware that detainees at the Fulton County Jail lived under conditions that subject them to the substantial risk of serious harm and death. The Fulton County Board of Commissioners has been aware that the detainees at the Fulton County Jail lived under conditions that could subject them to the substantial risk of serious harm. Defendant Labat was and remains a direct and proximate cause of the injuries, damages, and deaths of countless detainees at Fulton County Jail. Because of Defendant Patrick Labat's deliberate indifference, class plaintiffs are entitled to an award of damages for injuries, pain, and suffering of mind and body and death. Defendants have failed to address known safety issues, even though jail incident reports, public statements by Sheriff Patrick Labat, and other means of reporting have presented facts from which defendants have inferred that an overt and obvious substantial risk of serious harm exists for detainees at Fulton County Jail. Guys, I'm going to love to see the defense for this. Like, think of the uphill battle here. Like, how are you gonna counteract this? How are you gonna counteract this? I mean, this is an issue that, because of, some of the public statements, there's people all over the world that have seen an acknowledgement of the risky conditions, right? So I don't know. Can't wait to read that. Upon information and belief, the number of incidents of violence arising from handmade shanks, non-working or dysfunctional cell door locks, unsanitary conditions, excessive use of force, and the jail's failure to classify detainees is grossly underestimated in Fulton County Jail incident reports obtained via open records requests to the Fulton County Sheriffs. Plaintiff plans to uncover further defendants whose deliberate indifference caused injuries to detainees at Fulton County Jail in violation of the 8th and 14th Amendments to the Constitution. The unsanitary, bug-ridden conditions at Fulton County Jail and defendants' deliberate indifference to same caused plaintiff Nkenegen Hambrick to develop severe wounds and sores. Okay, so now we're getting into the named plaintiffs here and some of the damages that have been inflicted upon them. Again, that they're saying is a cause that is being caused by this deliberate indifference to known conditions. So, Hambrick was incarcerated at Fulton County Jail from January 19th, 2023 to June 21st, 2023. During his detention, Hambrick suffered severe wounds and sores on his torso and lower body as a result of unsanitary conditions at the jail. On May 25th, 2023, Plaintiff Hambrick was found lying on the floor face down in his cell on the 4th floor of the North Tower. The handwritten medical emergency code report memorializing this incident is attached here, and we don't have that exhibit. The handwritten medical emergency code, dated May 25th, 2023, states that responders were unable to assess Hambrick's neurological condition. The handwritten May 25th, 2023 medical emergency code report states that Hambrick was nonverbal, had rashes to his back and torso, and had negative physical findings for seizures. But the responder was unable to fully examine Mr. Hambrick. NAFCare service records demonstrate that Plaintiff Hambrick underwent treatment for sores on his back and right arm for dates May 6, 2023 to June 28, 2023. NAFCare service records memorializing Plaintiff Hambrick's complaints and treatment are attached as exhibits. In addition to the sores, Plaintiff Hambrick complained of mood instability and received medications to treat manic episodes, schizophrenia, and bipolar disorder. Following Mr. Hambrick's release, he treated at Peachtree Medical Center, Fayetteville. Peachtree Medical Center are attached here as, their records, Peachtree Medical Center records, are attached as an exhibit. On July 13th, 2023, medical providers at Peachtree Medical Center noted the reason for Mr. Hambrick's visit. Patient was in prison January 19th through June 20th. Has 20-ish stab wounds. What? Feels like he has bug bites. Possible spider bite on back of leg. So, and again, this could come down to the way they're writing this, but they're like, oh, they didn't have a chance to examine him. Oh, they didn't have a chance to examine him. Oh, they didn't have a chance to examine him. And then, like, retroactively, whoever's treating Hambrick after he's released and goes to this medical center, they have 20-ish stab wounds. Feels like he has bed bug bites, possible spider bite on back of leg. So this is from James Tippett. He noted the following: multiple skin ulcerations on the trunk and extremities of various size. They're erythematous. They are erythematous and superficial. There is a very large what does that mean? Erythematous. Abnormal redness of the skin or mucous membranes due to the accumulation of blood in dilated capillaries. Okay, so we learned a new word today. We speaking for myself, I don't know about you guys in the chat. There is a very large ulceration on his inner right thigh. Ouch. Photographs of Mr. Hambrick taken shortly after his release from Fulton County Jail demonstrate the serious harm caused by defendant's indifference to a known risk of harm at Fulton County Jail and are attached as Exhibit M. Oh my gosh. Another section here, the prevalence of shanks, non-working and dysfunctional jail locks, failure to enforce an inmate classification plan, and defendant's indifference to same caused plaintiff Shannon Jackson to suffer serious injuries from shanking attacks. On July 4th, 2022, Plaintiff Jackson suffered serious injuries in an arranged shanking attack and attempted murder in Zone 500 on the 5th floor of the South Tower at Fulton County Jail. Before the July 4th, 2022 shanking attack, Plaintiff Jackson was relocated from Zone 100 on the 5th floor of the Zone Tower to Zone 500 on the 5th floor in the South Tower. Detainee Jalen Stanley held a grudge against Plaintiff Jackson and orchestrated an attack on Plaintiff Jackson. Detainee Jalen Stanley was able to perform their attack by interfering with security operations of cell number 517. Plaintiff Jackson was taken to Grady Hospital for injuries suffered in the July 4th, 2022 shanking attack. If Plaintiff Jackson had been moved to a different floor instead of a different zone on the same floor, then detainee Jalen Stanley would not have had an opportunity to perform an attack. The July 4th, 2022 jail incident report is attached here within. On December 10th, 2023, Plaintiff Jackson suffered serious injuries in an orchestrated shanking attack and attempted murder in his housing cell 412 on the 6th floor of the North Tower. Detention Officer Shawan Nash was assigned to the 6th floor of the North Tower as the floor officer. Detention Officer Shawan Nash saw suspicious activity in the zone, so attempted to investigate, at which point detainee Lester Walker tried to prevent Detention Officer Nash from investigating, saying the detainees were arguing about the game that was on. So they're just like, no, bro, it's good. We're just like watching, I don't know if this was like a Sunday, we're just watching football. We're always getting heated because we got different teams. Don't go over there, bro. Detention Officer Nash investigated further, causing detainees to scatter. Then Officer Nash discovered Plaintiff Jackson covered in blood and requesting medical attention. Detainee Willie Brown had entered, and they had to delay the trial because of this. Detainee Willie Brown had entered Plaintiff Jackson's cell and used a shank to cause serious personal injuries to Plaintiff Jackson. Plaintiff Jackson was taken to Grady Hospital for injuries suffered in the December 10th, 2023 shanking attack. Detainee Willie Brown did not suffer any injuries in the December 10th, 2023 shanking attack on Plaintiff Jackson. There was no tower officer assigned to the 6th floor of the North Tower at the time of the attack on Plaintiff Jackson. If there had been a tower officer on the 6th floor of the North Tower, that tower officer would have deterred the attack on Plaintiff Jackson. The December 10th, 2023 jail incident report is attached herewith as Exhibit O. Now, class action allegations. I think this is where, so let's see, who are they saying would be the class, right? So all persons that have been and will be detained in Fulton County Jail at 901 Rice Street and who have suffered acute personal injuries, acute psychological suffering, or mental anguish, or death because of defendants' deliberate indifference to the known excessive risks to the health and safety of detainees at Fulton County Jail. So this is the common shared grievance that would make us a class. Plaintiffs meet the requirement of FRCP 23A1 for the following reasons. The class is so numerous that joinder of all members of the class is impracticable. Plaintiffs expect to show that the class consists of upwards of 1,900 people, representing the jail's capacity for a single day, who have suffered acute injuries as described above, and an unknown number of people who will be detained in the future. Class membership is ascertainable by consulting Fulton County Jail initial intake questionnaire reports and similar questionnaires reports prepared upon the detainee's release, jail incident reports. And this is great, right? This is a great, as you know, there should be these records, right? I know we joke about Fulton County record keeping, but there should be sufficient records to see who's been in and out. Records concerning classification and housing placement for detainees, NAFCare medical health records, all of this stuff's going to help us identify who could be party to this class action suit. There are questions of law and fact common to the class. The first question is whether an acute injury occurred while the person was detained at Fulton County Jail. Following that determination, common questions of fact include 1. Whether acute injuries occurred at the hands of a rival detainee wielding a shank. 2. Whether acute injuries occurred because a rival detainee popped open a cell door without authorization. 3. Whether the plaintiff suffered harm when housed in a zone that was patently unsafe, and such danger was documented, or should have been documented, as unsafe for that detainee. 4. Whether the detainee suffered injury or deleterious health effects from unsanitary living conditions, such as vermin or parasites or unsanitary food. 5. Whether excess force was used that would amount to a waiver of qualified immunity for the officer using force. And 6. Whether the medical care provided to detainees conforms to the degree of skill and care ordinarily required by the medical profession in general, under like conditions and similar circumstances. And I think this is where we might see an example of, like, sure, if there was like some type of reason you couldn't have evaluated the one guy on that one specific day, like the May 23rd, you couldn't examine him in the moment for whatever reason, but why were you treating him for a month-wide range of time? And he had sores on his body, which if you're treating the sores on his body, you should be examining the body, but you're missing 20-ish stab wounds, right? Would you say that rises to a normally expected under those conditions? I get it. Maybe in the immediate moment, you can't just do a full body check. But why, when you're treating someone for a month for something where you should be looking at their body, you don't notice 20-ish stab wounds? Isn't that weird? Is that reasonable? The final legal question is whether the act causing injury was in violation of that plaintiff's 8th Amendment or 14th Amendment rights. The policies and practices challenged in this action apply to detainees at Fulton County with equal force to lead plaintiffs Nkenegen Hambrick and Shannon Jackson and all members of the class, so that plaintiff's claims are typical of those of the class. Plaintiff Hambrick suffered serious injuries due to the unsanitary, vermin-infested conditions at Fulton County Jail. Plaintiff Jackson suffered personal injuries at the hands of detainees wielding shanks who manipulated doors open to attack Plaintiff Jackson, and at a time when no tower officer was assigned to his floor. Plaintiffs have been or are currently subject to the same challenge policies and practices as the class members and have faced or still face the same risk of harm as the class members. And now here, this is just like kind of like less specific, but as part of, accept us as a class, let our suit go forward, please, judge. But plaintiffs and their counsel will adequately protect the interests of the whole class. Plaintiffs possess no interests adverse to those of other class members. Plaintiffs are represented by the law firm Michael D. Harper, and Michael D. Harper has 10 years of experience handling Section 1983 claims for the deprivation of civil rights under the 8th Amendment and 14th Amendment to the Constitution, as well as cases of medical malpractice in a jail setting. Michael Harper was the lead counsel for the family of LaShawn Thompson, the detainee who was found dead and covered with lice and bedbugs in Fulton County Jail. In the case against Fulton County Jail, Michael D. Harper has devoted substantial resources and time to investigating this case, including multiple visits to Fulton County Jail, extensive document collection and review, interviews of class members, and interviews of other detainees and their family members. And then plaintiffs meet the requirements of Rule 23b1 and b2, and that defendants have failed to act on grounds that apply generally to the class, so that the final declaratory relief and injunctive relief is appropriate, respecting the class as a whole. Plaintiffs seek to represent the class in challenging the constant and known risk of danger, serious personal injury, and death to detainees at Fulton County Jail. Now, we're getting a little more specific and away from the things that we just got to say. But violence and danger run rampant throughout the multi-tiered Fulton County Jail structure. A single class action suit against the entities that provides essential funding and perform operations management is necessary to achieve consistent, permanent change throughout the jail and protect the rights of class actions, plaintiffs, and future detainees. Any prospective relief granted to plaintiffs with respect to those matters will necessarily benefit each member of the class, right? So this is, again, allow this to move forward as a class action suit. For the foregoing reasons, administrative remedies were unavailable. And now we're going to get to exemplary punitive damages and allegations. So defendant's conduct as alleged herein was done with reckless disregard for human life. oppression, and malice. The substantial risk of harm and death to detainees at Fulton County Jail was longstanding, pervasive, well-documented, and expressly noted by Fulton County Jail officials. Leadership at the Sheriff's Office and Fulton County Jail are aware of the violence in the jail and have publicly decried it, yet they fail to take adequate action to address the crisis, and homicides, stabbings, and other violent acts continue at dangerous levels. This was not done by accident or through some justifiable negligence. Such conduct was done with conscious disregard for plaintiffs' rights under the 8th and 14th Amendments to the Constitution. Accordingly, plaintiffs request punitive damages, where available, against defendants for the harms caused to plaintiffs. So, causes of action, guys, and, we'll read how many counts are they going to put here. It should be several. There are key elements, but sometimes they get repetitive. So I'm going to skip all the stuff that says we incorporate everything else we've said before, and we're going to skip some of the bulky reading, but the causes of action. So count 1, we've got 8th Amendment and 14th Amendment, deliberate indifference to substantial risk of harm and serious injury from pervasive presence of handmade shanks. The lead plaintiffs and class plaintiffs are entitled to the protection of constitutional rights under the 8th and 14th Amendment, including protection from deliberate indifference to their safety and well-being. So this is going to probably repeat itself a lot. This section here will probably see repeated. At all relevant times, the collective defendants were responsible for operating Fulton County Jail, funding operations at Fulton County Jail, directing activities of staff, detention officers, and detainees at Fulton County Jail, and conducting, documenting, and performing necessary and essential functions in the operation of Fulton County Jail. So they're in the time and place and have the responsibility, right? So just know that that's probably going to be consistent. We're going to skip this paragraph if it keeps popping up, but just keep that in the back of your mind, because we've been going about 2 hours. We've got 22 more pages to go, you guys. The claims against defendants are based on the negligence, policies, customs, and deliberate indifference of Defendant Sheriff Labat, Defendant Jackson, and this is going to be confusing. This is Defendant John Jackson, not Shannon Stillwell Jackson, who's the plaintiff, and all medical and administrative staff and detention officers responsible for the conditions at Fulton County Jail. At all relevant times, I see it's a birthday in the chat. Shout out, Emmy, happy birthday! Amy says, thankful to God for blessing me with yet another birthday, and I hope and pray for many more with family, loved ones. That includes the kattnotwilliams slime family. So big shout out here to Emmy Grace. Drop a birthday cake in the chat. Show some love. Look at that. Thank you guys in the chat. It's you guys here dropping the emojis that made me see it. So big thank you to you guys. Hope you're having a good one. At all relevant times, defendants acted under the color of state law. At all relevant times, defendant NAFCARE and medical professionals employed by NAFCARE acted with deliberate indifference to the serious medical needs of the class action plaintiffs, which constitutes the unnecessary and wanton infliction of pain to class action plaintiffs. Fulton County Jail detainees are at constant danger of serious personal injury and death due to Fulton County Jail's crumbling infrastructure, which inmates use to craft makeshift knives called shanks for use as weapons. The jail incident reports attached here within memorialize incidents in which numerous shanks are uncovered, in which detainees state that they keep shanks for protection, that they can buy shanks from others, and incidents in which shanks are used in assaults on detainees, including Plaintiff Jackson. So we have evidence that shanks were present and that a shank was used on somebody, right? We've got all that. Each defendant is aware that the pervasive presence of handmade shanks presents an excessive risk to the health and safety of detainees at Fulton County Jail, and each defendant has failed to take steps to reduce the risk of harm, violating the 8th and 14th Amendment prohibition against cruel and unusual punishment. And this is the point, right? We're spelling it all out. The defendants were in place. They were in a position to do something about it. They were present at the same time the plaintiffs were housed here. We're saying that shanks are causing harm. They didn't do anything about the shanks, and we have proof that shanks were there. So the argument is, our cause here, as a direct and proximate result of the defendant's deliberate indifference to the excessive risk of harm, the plaintiffs have been injured, have suffered severe, permanent pain, suffering, disability, impairment, loss of enjoyment or life, loss of care, loss of comfort, and economic damages, including but not limited to past and future medical expenses, lost income and other damages, Plaintiffs may also require additional medical and or hospital care, attention, and services in the future. We're going to see this stuff repeated a lot, and maybe some term will drop off once in a while, but essentially the same thing. These are the damages, and these are the things that we want to prevent. Plaintiffs seek compensatory and punitive damages, together with interest, to compensate them for the violations of their rights by defendants. Plaintiffs seek declaratory and injunctive relief on behalf of themselves and a class of similarly situated persons to prevent further violations of their rights by defendants. So now we're going to move on to count 2. And, these headers give a good summary of what exactly it is. We'll try to read some of the things that are substantially different, but again, a lot of what we just read in count 1 is going to be repeated almost completely. So 8th Amendment and 14th Amendment, deliberate indifference to substantial risk of harm and serious injury from non-working and dysfunctional door locking mechanisms. So you guys didn't take care of this door locking thing and it caused XYZ. And we want XYZ as relief for it. The lead plaintiffs and class action plaintiffs are entitled to the protection of the constitutional rights under the 8th and 14th Amendment, including protection from deliberate indifference for their safety and well-being. Again, same thing. We're going to skip this paragraph. The defendants were there and operating this jail. They had responsibility. The claims against defendants are based on the negligence, policies, customs, and deliberate indifference of defendant Labat and Jackson. And again, NAFCARE, the detention officers. At all relevant times, defendants acted under the color of state law. Again, repetitious. Yeah, so because these locks don't work, so Fulton County jail detainees are at constant danger of serious personal injury and death due to the persistent failures of locking mechanisms for cell doors and zone doors throughout Fulton County Jail. And we have some evidence to suggest this, right? We've got these jail incident reports attached here within. It's about an incident where the cell doors popped open. Each defendant is aware that non-working and dysfunctional cell door locking mechanisms presents an excessive risk. So they know that this was a problem. And as a direct and proximate cause of the defendant's deliberate indifference to these risks, here is the list of injuries again, right? Physical injuries, disability, loss of enjoyment, loss of comfort, medical expenses. So we're seeking compensatory, punitive, declaratory, and injunctive relief. Count 3, and again, this is really going to just be repetitious, you guys. So this is probably the point. The next issue here is failure to use correctional practices such as classification, housing plans, assessment of the likelihood of victimization, and consideration of gang affiliations. So again, defendants were in a position, they had responsibility. They could have and probably should have been separating people. We have records to demonstrate that they weren't separating people when they knew they could have. And that caused these damages, and we want this type of relief in return. So, and that's kind of this is always like, when you get to these final pages, it's so many words, you guys. But it's really just like kind of spelling out a little bit of the bullet points of what we've got to prove, what we've got to rise to the level. We've got standing, we've got the right parties, we're showing cause between the defendant and the action we're claiming. And there's enough here that would warrant a request for some type of relief here. So let's see. Again, this is, I think it's pinned at the top of the chat. It's also in the description. But this next one, count 4, deliberate indifference to substantial risk of harm and serious injury from the filthy, parasite, and vermin-infested, and overall unsanitary conditions. Count 5, this is substantial risk of harm, deliberate indifference, but, risk of substantial harm and serious injury from unauthorized use of force by detention officers. And we got a couple examples, but I think this might be one of the examples, like, as more plaintiffs decide they want to be named and actively participate in this class action suit, if a judge says, all right, I approve this class and you guys can move forward with this lawsuit, I think that this might be where we get some of the stories, right? Because if someone feels like they were the subject, and maybe like the vermin, but when nobody's listening to you, when you're trying to say something and someone responds to you by what you think is unnecessary use of force, that just seems like something you might want to get off your chest. So, I think we will have more examples of this. You know, we see some examples in the DOJ report, but I think we'll see some people come forward and share their specific stories and experiences throughout however this progresses. And again, they're referencing those exhibits that they mentioned, but we don't have them attached to look at. Count 6, deliberate indifference to substantial risk of harm and serious injury from inadequate provision of health care, including, got a typo there, mental health care. Count 7, deliberate indifference to substantial risk of harm, inadequate staffing and supervision to keep detainees safe. I think this is where Stillwell's example really comes into play. You didn't even have somebody on this floor. Yeah, so they cite the Plaintiff Jackson example here. And then prayer for relief. So what are we looking for? What are we looking for? For the foregoing reasons, plaintiffs respectfully ask that this court, 1, assume jurisdiction over this action. 2, certify this case as a class action under Rule 23 of the Federal Rules of Civil Procedure. 3, declare that defendants are violating the 8th Amendment and 14th Amendment rights of plaintiffs and other class members as described in this complaint. 4, enter preliminary and permanent injunctive relief against defendants, requiring defendants to so do this as a preliminary measure and make it permanent. Develop and implement a comprehensive plan to reduce the availability of raw materials that are used to create handmade shanks. So address the shank problem. This class action case, if it moves forward, could take a very long time. So judge, we're asking you, do something ahead of time so more bad things don't happen. Establish policies that ensure safety and security of all people in Fulton County Jail and ensure all staff adhere to them, including by training staff, supervising staff, and holding them accountable for violating jail policies. And C, establish generally accepted classification systems and housing plans for incarcerated people that incentivizes pro-social behaviors, disincentivizes misconduct, and offers adequate protections to vulnerable populations. And D, conduct an exhaustive review and analysis of cell door locking mechanisms and zone door locking mechanisms with the so please, judge, as preliminary relief, please just fix the door locks. Make them fix these door locks. Conduct an exhaustive review and analysis of cell door locking mechanisms and zone door locking mechanisms with the primary goal to eliminate detainees' ability to pop doors open or hold doors open without authorization, and consider replacing or modifying the locking mechanisms to eliminate failures and improve detainee safety. And E, retrain staff as to the use of force requirements, modifying existing plans and policies to adhere to constitutional standards for use of force, promptly discipline staff for misconduct, and this could actually hurt them a little bit. I mean, I don't think it'll shake the whole tree, but if you're saying modify the existing plans and policies to adhere to constitutional standards, this might suggest that the materials that we're supposed to be agreeing to and revisiting and, these are the current policies in place. This kind of suggests that the material they're looking at is inadequate, right? And that might walk you away, that might distance you from we know what we're supposed to be doing, but maybe they don't. This is kind of, but again, I guess for the greater good, make the policies adhere to constitutional standards, I guess for the greater good, put it in here as relief. Implement and ensure adherence to thorough sanitation policies, ensuring regular, scheduled cleaning and sanitation for all areas of the jail, in particular cells, medical areas, and food preparation areas. And develop and implement a comprehensive integrated pest management system for all parts of the jail to reduce/eliminate pests. Some of this just reminds me of when Max Shart wrote that motion for a fair trial, and Whitaker was like, a motion for a fair trial? I mean, yes, I guess I'm going to grant this in part, but I'm not going to grant the mistrial part. But of course I'm going to grant the motion for a mistrial. It's kind of like some of these asks are like, oh yeah, I guess we'll just grant this relief preliminary because that's kind of crazy. A little bit, And modify and implement policies, procedures, and practices for medical care in the jail to ensure adherence to constitutional standards for responsiveness to medical needs, including but not limited to mental health treatment. Implement a grievance procedure that is readily available and adequately responds to grievances filed by detainees. Fix the kiosks. 5, enter judgment in plaintiff's favor for compensatory relief for injuries. Yeah, I don't think this is a huge ask. I don't think we're going to do this. I don't think we're just going to get some type of summary judgment here, but might as well ask. But enter judgment in plaintiff's favor for compensatory relief for injuries suffered at Fulton County Jail, which were caused by stabbings, health conditions arising from unsanitary and bug-ridden conditions, and excessive use of force by detention officers. Enter judgment in plaintiff's favor for punitive damages together with interest, and that a jury trial be had on all issues. Oof, I was wondering, but they've got pictures, you guys. And again, they're focusing on a jail, not a prison. So they're going to take away this, like, yes, there are people that think that if you've been arrested, you must be guilty. You must have done it, right? But that's a much smaller pool of people than, well, if you're in prison, what do I care about your conditions, right? The fact that this is talking about jail conditions, and that's not my stance. That's not my stance. But I'm saying the general population pool going through voir dire, it's a little bit easier to see a jury that's not just going to sit there and think people awaiting trial, right? Pre-trial detention just deserve all they've got coming to them, right? So I think this is a big advantage here for the plaintiffs for a jury trial. But then you've got these pictures. You make them imagine being eaten alive by lice and bed bugs. Like, a judge, bench trial, judge might be able to distance themselves from that type of thing more than a jury would. So they're asking for a jury trial. Award plaintiffs reasonable attorney's fees, expenses, and cost of litigation. So get us paid, right? Don't make our plaintiffs pay out of pocket. Make them pay for it. Make the defendants pay for it. A written consent decree monitored by the court to ensure the completion of the aforementioned requested relief. So monitor this, make sure they actually do these things. Award such other and further relief as this court deems just and proper this 10th day of December 2024. And then again, this is penned by Michael D. Harper. And what were some of the other names that we saw? Patrick Lead is here as well. Was that all they mentioned at the top? Yeah, okay, cool. So we're going to get used to hearing these names, I think. And again, this could probably take a very long time. So in a couple months, we'll find out if this is going to move forward or if it needs to be adjusted in terms of the class, how it's being defined. Oh boy. It's nice to see. It's nice to see. And I think some of the things like, if someone's choosing to try to attack somebody in prison, but they're able to do that because the locks don't work, seems like a problem that the facility, the staff should have some, it seems like, deliberate indifference. I can see that being pretty easy to prove. And I would feel like this would be a much harder uphill battle if there was only like one incident, right? Oh, that could just be an individual acting and the chances all align. They slipped through all the holes in the Swiss cheese and were able to get this thing they wanted to do done, right? But at the same time, if it keeps repeating, why are all the stop gaps? Why are they all missing? Why are we consistently able to do these things that shouldn't be happening with none of the stop gaps in place, right? So that DOJ report, I mean, I'm glad to see this class action suit come forward. Waiting to see what happens with it. And yeah, Andrea says, I think people would have different standards if it was their kid or brother or friend in that situation. Yep, and a lot of people, it's one of those you don't know until it happens to you type of situations, right? The stance that people, broad stroke. Well, surely, why should we care? Surely they're in there for a reason. That whole mindset is, a bit easy to shake when suddenly it happens in your camp. Purple Pro says, yeah, skip the implements, go straight to accountability. get it done and follow up to make sure it's getting done. Right on time here, GV says remember to stream Lizard Walk. Let me drop a link to that. So Shannon Stillwell posted, it's on like Apple Music and Spotify. I'm just going to grab the YouTube link because I think I can safely assume that everybody here in this chat uses YouTube. But he did upload Lizard Walk, and he used the picture of him and Shart. So I'll drop this link there. It's Lizard with 2 Z's if you want to search it anytime. But yeah, interesting to listen to this after the acquittal here. So there's that in the chat. Thank you, GV, for the reminder on that. Now, Black Butterfly says, Cat, that moment was classic. I was hollering. This has to be about the wheelbarrow. Right? Was this the wheelbarrow moment? Just the dramatic entry pushing the whole wheelbarrow of shanks that we're confiscating. It's like, it reminds me of the day that we first got to see the evidence cart rolled in the YSL trial. Like, yeah, we know they've got to move evidence in and out of the courtroom. But seeing the way they, like, carted it in on that particular day, like, the chat was dying. There was, like, shopping cart emojis all throughout the chat. So I always love moments like that. They become memories. Michelle Warden says more money will not fix these issues. New staff, sheriff, and all the DA's office should be held accountable. I do think they need to spend money to fix certain things, but it's kind of like a cut your losses problem, right? Like, this facility just seems so far gone. And in the DOJ report, they talk about, like, you know, we did a little bit of maintenance on this one small part of it, and it took us like 12 months to do it, and it's making like 12 beds usable again. Well, is that really like an efficient use of time and resources? So that's kind of a whole mess. Oh, Asia Mullen says I couldn't find Lizard Walk on Tidal. It might not be on there yet. I think it says that it was he was using DistroKid, so it might just take longer for it to go up on there. Oh yeah, we can end this out with ABCs of Steel. I did see it was a short clip. Let me see if I can pull it up quickly. And it was shared by user Gold 2, so thank you for that. And I didn't really get to watch it, but there was it's a 2-minute video. And we get a small clip here of the district attorney. And what is okay, so former Brunswick District Attorney Jackie Johnson was charged with illegally interfering with police investigating the 2022 killing of Ahmaud Arbery and has made her first court appearance Wednesday. And there is a clip in this news report of the defense attorney and then Brian Steele, and I think they're arguing about Brady issues. So if you want a little throwback, you miss Brian Steele a little bit. There's a little bit for you here.
Now, during the pretrial hearing today, prosecutor John Fowler accused lead defense attorney Brian Steele of trying to steer Johnson's case into a gray legal limbo where no one would prosecute her.
Okay, no offense. Like, I mean this with love, but I mean this with care. I don't mean like Adrian Love. That sounds like something that Brian Steele would be doing. Not without reason, but that sounds like Brian Steele.
By trying to make Attorney General Carr a witness by speculation without subpoenaing him and trying to come up with some vague reason, they're trying to get this case into a place where it cannot go forward.
If the head of the office, the elected district attorney, or in this case, the elected attorney general, has a conflict, then all of their people who work for them have a conflict.
What do you think of that? I mean, that was the extent of the Brian Steele mention and appearance there, I think. But doesn't that seem spicy? Doesn't that seem spicy? And I don't know when the next date will be set. Maybe we can try to catch a stream live and see the arguments. The tweet I saw, and again, shout out to user Gold2. mentions Keith Adams also getting heated, so maybe they're working together on this case as well. That'd be really cool. But we can take a look at that. But hilarious, he said, what did he say? A gray legal limbo? Just to prevent prosecution in this case. I mean, honestly, like, that's a Steele strategy, but I don't think he does it baselessly. But yeah, classic Steele. Classic Steele. Yeah, Violet says, I've got so many windows open that I'm afraid my computer may crash. That was me when I started this stream, from having all the different... You know, I should get an ad blocker, but pulling up different articles and having them handy, those article web pages just have like 1,000 videos in the margins, and it's just a whole mess to have those tabs open. But I feel you on the tabs. Let's see. Okay, Michelle Warden, can you repeat? I'm sorry, did you see my post, important info? Do you mean post in the comments here, or is it like a post over on X? You can put it in the regular chat, because I'm looking now that I'm not reading. That way I know where I'm looking, and I could either scroll back in here or find on another platform. Nurse Jenny, thanks for being a member for 5 months. And Paulette C, hold on, we got 5 more honey baked hams, you guys. Let's shout out Paulette in the chat. So we're up to a total of 12 honey baked hams gifted today from FFS, and now Paulette. That is, like, the honey baked hams thing, you guys, is just another level. Like, the way that the DOJ report specified that they were using this money to buy honey baked ham gift cards for staff that was supposed to be spent on the inmates was just like... And I see Michelle here, but just going steal, steal, steal. And let's see. We're looking for an article here from AJC. Yeah, it's annoying the, you know, in certain other countries, you can't read AJC articles. I really like, that's Atlanta Journal-Constitution. I really like their journalism, their stories, the amount of, you know, they cover things, even if it's a small update, so you're not just missing things in between bigger updates. They kind of like keep on it, and they don't really forget the backstory. They always try to pull in some of the backstory context in case you're coming into a story late, or it's been so long you forget. A lot of their articles on the YSL updates, they'd refresh who's still left in the trial, who's awaiting trial, who are they, who took pleas. Like, they always recalled the important information back to the forefront when they did new updates. So it really sucks that they're not available in other countries. But let's see if I can find it, and I can download a PDF of it, maybe help you read it. Is it a new thing, or are you talking about Terrence Bradley? Or the other business partner, Chris something, I think. And I'm kind of jumping into a conversation that I missed the context for, but... Do you know what time frame? If it's older, can you actually, Factual Lie, are you able to get the URL, even though you can't actually see the article? If you can see the URL and you want to like send it on Twitter, just message me. I'll help you read the article so you can see it. Shout out to that guy, Nick. Thanks for hanging out with us today. Have a good rest of your night. And then Michelle Warden, okay, says, the man that stabbed Shannon is Willie Brown, who literally stomped his own baby to unalive. Are you serious? Oh my god. I mean, I guess, like, technically he's awaiting trial, right? You know, so still has the presumption of innocence there. That's crazy. I mean, you would think that, like, an allegation of something depraved, dangerous like that, make sure you pay attention. Watch your zoning and classification on that. Okay, alright. Factual Light, if you do ever, I mean, you know the drill. If you need an article, just message me. But there we go, you guys. There we go. What else is up? I think I was like, chat, do you know if Flesh of the Gods is doing a YSL stream tonight? And then I didn't actually pay attention to the answer, but I think he is. So let me see. I know I can set up a redirect to Flesh of the Gods. I can't do a redirect to AV to the 7th power, but I believe she's going live they're both going live at the same time. So Flesh of the Gods is doing a deep dive into the APD gang experts, right? So you've got Dennis, you've got Gaither, you've got Underwood, you've got Viverito, you've got Belknap, you've got a whole hodgepodge there. So there's a YSL dive linked in the chat, and we'll redirect over there. And AV is doing a conversation about this lawsuit. So if you want to continue the conversation, if you want to catch the details twice, if you want to get AV's perspective on things, or especially if you joined late and like missed the full half of it, you can get the beginning over there. I have to link to AV, I can't redirect, so that is in the chat as well. And we'll do ABCs of Steel on the way out, and see you guys over in... I'll jump around between both chats, so I'll see you guys anywhere you go. And again, I may or may not do Courtney Clenny stuff tomorrow, right? There is no actual new status hearing tomorrow. I said I would cover that tomorrow, but there's just not going to be one. But we might do a rewind all the way back to her bond hearing in 2022, which was a mini trial. It was like 6 hours long. And they presented a lot of the evidence they expect to use. So the prosecution did. Let's get this redirect set up. And it was great to see everybody and hang out. It's nice to see some people. You know, it felt weird. I've seen like some people in some chats, but other people are like, I miss everybody. So glad we got to hang out. See you at some point, right? We've got tons of stuff coming up. But other than that, thanks so much for coming to hang out, especially on a tougher topic. So, and shout out to FFS, little boop. You guys all have a good night. Let's get to this classic song here. Where are we? There we go.
A as in Alicia, and B, Your Honor, as in Barry. C as in Colette. G as in Goldfetter. K as in Kittens. M as in Magic. P as in Perfect. C as in Colette. U as in Unbelievable. V as in Victory. W as in Wonderful.
O for objection. S for sustain. E for buffering. E for Petrovane. S for sly, my friend, and you, as in what you mean. I as in adultery call. M as in may I sleep. All the ABCs of steel makes me feel so real. Yeah, they keep on spinning round. Never gonna let me down. G for gavel stands down E. T for tell 'em anything. R for rights we stand. I for infinity. Life's a courtroom dance. Keep your stances strong with ABCs of steel. You can never go wrong. Oh, the ABCs of steel makes me feel so real. Yeah, they keep on spinning round. Never gonna let me down. Steel makes me feel so real. Yeah, they keep on spinning round. Never gonna let me down. Oh, the ABCs of steel makes me feel so real.